Good evening and welcome to the October 17th meeting of the Falmouth Zoning Board of Appeals. I'll be calling the meeting to order and also ask everyone to please silence their cell phones at this time. I'll introduce the board, starting at my far right. Your far left is Jerry Patamas, who is a full voting member, followed by Ken Foreman, who is our vice chairman. My name is TJ Hurry. I'm the chairman of the board. To my left is Ed Van Kuren, who is a full voting member, followed by Bob Dugan, who is the board's clerk, and Mary Berry, who is an associate member. Also with us tonight is Noreen Stockman, who is the zoning administrator, and Ashley DeMello, who is our recording secretary for tonight. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town and considers requests for special permits, variances, and appeals as provided in the town's bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. All decisions are made through the public hearing process. The board's goal is to hear testimony from the applicants and from the public to allow a full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcement of the hearing and then present any pertinent information from the file, such as referrals from town departments and correspondences to and from the board. The applicant or the applicant's representative will have 15 minutes to make a presentation, and time may be extended by vote of the board. The board will then question the applicant, and the public will be invited to comment as well. Public comments should be directed only at the project, and we also ask you that you please refrain from making any personal or derogatory statements. But such public comment can include an opinion in favor or in opposition, or it just might be a question about the nature of the project. The chair will limit discussion in the interest of time if comments become repetitive. All members of the public wishing to speak should wait to be recognized by the chair. Please come to the podium to your left. We'll ask you to state your name and address for the record. And we typically limit public comment to 2 minutes per person. We will then either close or continue the hearing when the board is satisfied that enough information has been presented by testimony and in the file to make a decision by motion and vote of the board. The hearing will be closed. Alternatively, we may continue the hearing to a future date and time. After the hearing is closed, no more testimony may be taken. As for board discussion and decision, the board may then further discuss the project among ourselves, and a motion to deny or approve will be made and voted upon. Such a motion will include a summary of key findings and conditions. An affirmative vote of 4 members, which is a supermajority, is required for approval of motions on special permits, variances, and appeals. A split vote, such as a 3-2 vote, is a failure to carry and would result in denial of the project. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different. So turning to our agenda items for tonight, we do have public comment. We have 5 continuations and 5 new hearings and also items on our open meeting agenda. So first, we do have public comment. This public comment period is for anything that's not on the agenda tonight. So are there any members of the public that wish to comment on anything that's not part of our agenda tonight? Okay, seeing none, we'll move to our continuations.
So I'd make a motion to take one of the applications out of order, 20-19, Mewad 0 and 213 North Falmouth Highway, North Falmouth. We did have somebody come up to do a pro forma review, and that person is here tonight.
Okay. Is there a second?
Second.
Motion to take application 20-19 Mewad out of order. That was made by Bob and second by Ed. All those in favor?
Aye.
I just had a question. Why are we taking that out of order?
Well, the person that did the pro forma statement's here tonight, so they're
Won't
gonna
they be here in another hour?
no, they're gonna review that with us and then head back from where they came from.
Okay, so they have limited time
They have
in front
limited
of us.
time, yeah.
Okay.
All right, so the motion carries, and we will open application 20-19 Mewad.
Hello, thank you for taking it out of order. Appreciate that. My name is Maura Kamasi, and I was asked to do a pro forma review for the project. I provided that review and I sent it to the board. Does everybody have a copy?
I think we do.
Okay. So I did the review in 2 parts. I did it based on the the cost and how much profit would be received, because that was one of the concerns of the applicant. And if you look through, I don't want to read everything I said, but just for the point, everybody else, it shows that the original budget for the 12 units of market rate units and the 4 affordable, the profit was 17.9%. Over the course of the past week or so, since the square footage has increased on the project for some of the units. So when the square footage increased, they did that so that they could get a more sale price, but also the construction cost also increased in order to build the more square footage. So that's the updated budget here. So that shows a 17.59% profit. And I received a number of pieces of information about the various septic system options that were being talked about. And if you look at option 1, which was the least expensive septic system option, and just a caveat to that, I am not a septic system expert. I just looked at the documentation that was provided for me, and some of these I think are actually low ball numbers, because it assumes that there's a Title V system already in place, which is not the case. So let's just, for the sake of argument though, say the cheapest system that could be put in is a $350,000 system. That would bring the profit to 12%. So if there was a system that was less expensive than that, then it may get into the 15% range, which would make the project feasible. But that is not what was presented to me. So that is the first one. The other two options were the more intense IA systems. They were the $600,000 system and a $950,000 system. It shows a profit of 9% and 3%. So that's the first analysis. The second one was based on income restrictions. The way that the affordable units work, individuals can only pay 30% of their income to housing costs, and the last page of this details what that is. In Falmouth, the 80% of area median income is $73,200. With the housing unit at $220,000, which is what it would set at, that would mean that the max housing cost per year could be $21,960. With a housing cost per month of $1,800. So that would mean that all of the housing costs, which includes taxes, insurance, principal, private mortgage insurance, what people would have to pay in this scenario because they're only putting 5% down, insurance, homeowners insurance, condo fees, all of that stuff, that would equal $1,600. And the reason that I did this analysis and why this is important is that these septic systems, the IA systems require maintenance, either monthly or quarterly, oftentimes both. And so that puts another amount of money that is required for the homeowner association to pay. And so that would increase this amount. And there's a little bit of a cushion in this amount, about $100 and so, a little less than 200, more than 200, sorry. And that is possible to put that in there. But these systems seem to have more than that in terms of the per unit cost for the maintenance. So that is the analysis.
Thank you. Do we have any questions?
Yeah, I have a question. One, what I have in front of me is unsigned.
Okay.
Do we have a signed document? Do we have a signed document? The 3 pages I have, there's no signature on it.
So that's just a presentation of the findings.
Okay, but,
I'm happy to sign it. I'm happy to sign it.
no, I think I understand it's an overview of the findings. Do we have the exact report? Yeah, it might be minor, because that's probably the least concern I have. So we have a signed report.
No, so the copy you have is the report that was just issued.
So we don't have anything signed.
Correct.
Okay. That's significant to me. What is your qualification for the pro forma? Do you meet the state requirements? Or?
I'm not sure what the state requirements are. I'm a development consultant. I've been doing this work for over 10 years. I was asked by the town. I was referred.
So you're satisfied she's capable of doing a pro forma? The other thing I have is more on the septic tank. This relies on the Buzzards Bay report and the West Falmouth. And I know this is not your area of expertise.
It's not only that report, it's that report plus information that I received from Clean to You from the manufacturer of these septic systems.
Okay, so they're the technology vendors' specs for the various systems.
They manufactured, they put in a lot of information. I can send you what they sent me. There
Well,
was,
trying to get understanding, because my concern is those systems are yet to be approved by the state. They may not even be acceptable to the town, depending on how many we put in, and whether they can get a waiver under a pilot system. And I know that's not your area of expertise, but it seems to go to what I would say the overall, my ability to accept this without serious question.
I think that I'm not making a recommendation either way. I'm presenting the information. And then if there's a system that is significantly less than this, then it would be
That I don't
appropriate.
know what systems you compared. I'm a little bit familiar, but not all, with the systems that are going into West Falmouth. There's 6 or 7 of them. You don't know what level of nitrogen reduction these systems represent? Have you costed out?
I don't. Not exactly. I mean, I have the documentation that I worked from, but I can't tell you at this moment what they represent.
Okay, thank you.
Any other questions from the board? All right. Ken, anything?
Well, do you know, under Chapter 40B, are there limitations to the amount of profit developer can make?
There are limitations. I'm not sure the
So I
exact number.
can help you with that.
Yeah.
So when all the cost analysis is done after occupancy, there's a financial review, and any profit over 20% is returned to the town. So the developer is capped at 20%. And similarly, the state will also offer guidelines, whereas the profit is so low that they would consider it uneconomic.
And what is that, do you know?
Ballpark, like 12 to 15, somewhere
it's
in
around
there.
50.
So it's a very tight margin where it's feasible for them or not.
I used 15 as a baseline. That would be the uneconomic.
Okay, thank you.
So this discussion is strictly on this, not what we're going to do with this information.
Correct.
Okay.
Any other questions? Okay, thank you.
Great, thank you.
We do have the applicant's representative here tonight.
I believe so.
I don't see him.
Thought I saw him here.
I know he
earlier.
was here.
I guess you can just continue it perhaps and,
Reopen it up.
yeah. I don't see him now. I thought I saw him earlier.
Move to continue?
All right.
Second it.
Move to continue made by Ken and second by Ed. All those in favor?
Aye.
Aye. All right, so that brings us to application 50-19, Kelly, 165 Akabesket Road in East Falmouth. For the applicant?
Okay, so we were asked to come back with information on a proposed expanded leaching field. You should have before you a plan that shows an engineered leaching field, along with the reserve area. I'm sorry?
So they did submit Two plans, one stamped October 2nd, and one stamped October 3rd. On the October 3rd, they did show a reserve area for a four-bedroom system if they need to put one in. And on the October 2nd, they modified the plan to show the space as unfinished, except for heat and rough plumbing.
You passed it.
So the septic is the top one, and the other one's A2.
And what did we get, or maybe you can explain from the Board of Health, that was the big issue last time.
Yeah, that was
I
about,
saw some stuff in a,
yeah, that was about leaching. We were supposed to show a proposed area for expanded leaching.
I think you're supposed to show if the septic tank itself, oh, yeah, okay, not the reserve area, the expanded area.
Right. The expanded area, we also put the reserve area in there. We had that engineered rather than just where we think that it might go, so it's been,
Bottom line, is this acceptable to the Board of Health?
So we do have a notation from Scott McGann from October 17th regarding 165 Acapesca Road, and he wrote, "The contractor and I have been going back and forth with emails regarding the property concerning finishing above the garage and needing a four-bedroom system. He showed me a preliminary, incomplete plan that does appear to show that a four-bedroom septic system could be sited on the lot. However, to be 100% sure, I would need a full design and permit issued to say certain."
Excuse me, Ed Montero, I'm the builder. The only reason why we're showing the leach field was if the garage is ever finished over in the future. Other than that, what we propose right now for the garage and the existing home, everything does comply. The only reason why the Scott McGann said the engineering has to be complete, a perk test has not been done, which would just show the soil evaluation. But for the board's purposes, I believe it was Mr. Foreman wanted to see if there was enough room, if a leaching field could be placed on the property for a four-bedroom house, and it does, it shows it to the rear.
That's next to the current one.
That is correct.
I saw the plans a couple of days ago.
That's correct.
So on that unfinished area where you're noting the rough plumbing, electrical, and heating and gas, is the heating actually going to be installed, or is that also rough?
Just, it'll be the rough ductwork and everything else, because everything will be finished off in the garage. We don't want to have to take everything down and go back up with all of the electrical, plumbing, or the rough heating ductwork.
Any other questions for the applicant?
Yeah, and we might have to get, before we close the hearing, some discussion. Part of the issue is that when we approve something, we say, we stand a requirement, no matter how minor the changes, you have to come back in front of us. Right now, we have a unfinished upstairs with roughed-in plumbing, which looks like it's gonna be finished at some future time. And the board's concern was that becomes a fourth bedroom. If it becomes a fourth bedroom, you could convert another room into a non-bedroom. We need Board of Health approval. And I don't know if the other members of the board would be applicable to avoid having to come back in front of us. Would you be acceptable to say that prior to finishing the upstairs, you go back to the Board of Health to get a Title V permit?
absolutely.
Yes.
Assuming you're putting in
That's
there's
correct.
room for.
Right.
That was the big deal, is there room, so we're gonna assume.
Okay.
And it would be required anyway by the building department and the Board of Health to
It's
conform.
Different boards have different stovepipes.
Mhm.
I'm trying to avoid us necessarily have to see something if the approval is really in another department, the Board of Health.
Mhm.
Unless there are some other things that I didn't see anything in the discussion that we've had prior.
Any other questions from the board?
Yeah, I have a question. It says on the plans, if I recall, that it's storage area?
No.
No, there was never any storage.
No, this is a garage with living space over it.
Living space?
Yes.
Okay.
Anything else, Mary?
Well, I guess my question would be, what is the purpose of this
I think I know where you got the word storage from. I mentioned last time we appeared before you that the size of the garage is that size for containing the boat that I currently have, and for storage from the current shed that I have that I'd like to get rid of. So the contents would be going into the garage in storage. Yeah, I think that's where that word came up during the last meeting.
The first floor storage,
I'm sorry?
first floor
It's in the
storage.
garage.
In the garage.
Yeah.
So the garage will take the contents of my shed, so I can remove the shed from the property.
Do I recall you're housing any mechanical equipment on the second floor? That might be what Mary's thinking of.
Housing mechanicals?
Any mechanicals on the second floor? That might be what she's thinking of.
No, there'll be a heating system, a forced hot air heating system in the attic area to provide heat for the living space. And there'll be a Modine, a gas-powered Modine heater down in the garage for space heating.
Any other questions from the board? Any members of the public have any questions, comments, concerns regarding this project? Seeing none, back to the board.
Motion to close.
Second.
Okay, motion to close by Bob, second by Ed. All those in favor?
Aye.
Aye.
I make a motion to approve this with a unfinished area above the garage, except, per plans, except for roughing in.
All right, so motion was made by Jerry, and is there a
Second.
second by Ed? We'll go to findings.
They submitted documentation that a leach field, an expanded leach field, was available next to the existing leach field, which is in the rear, and there's existing space for a reserve area.
That's correct.
However, the Board of Health will require them to submit more detailed engineering plans along with a Title V application, subsurface disposal, if they choose to have 5 bedrooms in total on this premise.
It's actually 4.
Four.
Four beds total.
5, sorry.
Anything else for findings?
Yeah, so the addition is being done in a slab. It's a 30 by 36, a garage.
Yeah, garage is on a slab, and then the breezeway's on a frost wall.
Yep, and there's a 10 by 10 breezeway enclosed.
Mhm.
They got a front yard designation change to Gary Avenue for the building department. The two updated plans in the file that we'd be going by is the October 2nd stamp plan and the October 3rd. The October 3rd is the one that shows the reserve area for a 4-bedroom with an eventual expansion. And the October 2nd shows the change in the application, that it's now unfinished space with just rough plumbing, electrical, and heat. And as far as the heat, it's just duct working. Meets 240-23G1. 240-216, not more substantially detrimental. Increases utilization of the property.
Adequate disposal of wastewater. I think that's in that laundry list.
Yeah,
It's
the
covered
current
by 240,
three,
260.
the current property is a 3-bedroom
Okay.
property and is currently staying as a 3-bedroom.
All right, any other findings? About conditions?
So it'd be per plan stamped received October 2nd, 2019, and the updated plans of October 3rd. The application showing it as unfinished space only, which differs from the actual original application, which showed finished space.
We want to put a condition, they have to go
Yeah,
back to the
if-
Board of Health.
Well, actually, I'd like to put in if the applicant decides in the future to finish the space, he needs to submit plans for a modification to this permit prior to his building application.
What would that get us?
Well, we're seeing a plan in front of us now that just shows an open square box. So we have no way to know what will eventually be finished up there or not.
And what would we be concerned with?
Well, there could be other rooms that are put up there that meet definitions of bedrooms. There
But-
could be situations with additional kitchens, living areas that is not dealt with directly with the building department. And-
Well, wait a minute. I guess my concern is having to come back here, if there's a way to shortcut it, that the Board of Health says it's okay, bedrooms, everything else is a building department issue, unless we could handle it by administrative review.
So our plan that we have in front of us now, the issue is it's an empty, giant empty room. So we have no idea what the eventual finish could be. It could be fine with no issues, or you could at that point, and who knows if things change in the future,
Well,
or
we
how
could,
long this is gonna be.
well, we could say that they won't put more than one bedroom up there, they'll put a kitchen, and they'll put a bathroom and kitchen and sink. I mean, what I'm trying to do, I know what you're saying, but this is fairly straightforward, it's
So
unfortunate.
if we break it down that way, and you decide to go that way, they would have to tell us now what they're gonna put now versus a change, because if there's a change, they'd have to come back here anyways.
I think,
And right now, they're saying they're not sure what the eventual finish date is even gonna be, or
I
what they're
thought,
going to do.
well, I don't know how we get a question.
I think that-
Clarification, can we get a clarification?
Well, I think part of the circumstance for the board as well is that you would want to know what the finish is so that it doesn't become an accessory apartment absent your review.
It can't become an accessory apartment absent. I mean, I think we're putting conditions in that are important but unlikely based on previous testimony in the previous plan that's not sacrosanct. But it is obvious that they're gonna have a room up there that's big enough to be a bedroom. They're gonna have a kitchen area, plumbing, and I forget, the laundry and things like that. All I'm trying to say is there a way we can structure this that if we have to see it, we see it as administrative review.
How do you know what it's going to be?
We-
You've
we-
just assumed a whole lot of things that
Well,
it
no,
may
we
or
just
may
put
not
it,
be.
no, we just put it in our findings, because that's what their testimony was previously. There's gonna be a bedroom, a kitchen, whatever, if we have the,
Then why aren't we looking at plans that show that?
Originally, we submitted those plans showing that, and we were asked, because I decided to hold off on the finishing, we decided to just take out all of those areas and just, we were asked to change that from den to unfinished. There-
I understand that.
but the issue was, and if I remember, correct me if I'm wrong, is really a matter of cost. How much money he wanted to put into the project this year and, let's say, through this building permit. If he took a complete building permit out, he'd be obligated to finish everything. This way, he gets his cake and eat it too. We're satisfied that he goes forward with what he told us he was gonna put in, a bedroom, almost the previous plan.
So let's assume in the previous plan, we would go by that, and there's a kitchen, a living area, a fireplace, a bath, a bedroom.
Correct.
What would define that would not be a separate livable area?
This,
It wouldn't be an accessory apartment, because it's too big to be an accessory apartment.
plus, the entrance comes in from the main house anyway. So you don't
So can you-
We could put a
you
condition
don't
in
have
that-
separate set of stairs on the outside going up to the garage. And the only reason why we came back was when you thought it was a bedroom, the issue became whether or not the septic system would be
Well,
for
no, I
a
understand
bedroom.
that, and that kicked in the septic, and that was the
Yeah.
biggest issue. So where it did kick in the septic, and the other thing, we didn't get any further discussions on the rest of the plan that there might have been questions on. But if you want to put a condition in there that says that it can't be used as a separate habitable unit or living
You
area.
mean like a two-family?
Well, I guess that's
I
the
think you-
worry is that.
That would come down to the building department. That would come down to the building department and also the Board of Health.
Well, I
it can't be
understand
an
that, but
I know
we've
what
had
they're
some
saying.
issues so
It
far
can't
with the
be
building
an accessory apartment. We could put a condition in.
How do you keep it from being an accessory
It's too
apartment?
large to qualify for an
large.
accessory. It's over 850 square feet.
Right, but the use,
The building
You don't
department
look at the
would
use.
see that. I think we have to trust some of the other departments. I mean, why do we have 3 and 4 departments reviewing this if this board has to review everything?
So
If
the-
we really think this is gonna be a two-family, then we could say it can't be a two-family. It can't have separate rentals up there. At least try to give this applicant the break of going through an administrative review rather than coming back here, because I don't see there's anything we need to review.
So administrative review is insubstantial change,
That's correct.
so would you call whatever they're gonna add in, whatever they finally decide, whenever they decide to finish it off, how do you know it's an insubstantial change?
I would say if they, they can't put more than one bedroom, anything more than what was in the draft plan that we have. It can't be a separate habitable living area.
So then you're gonna have to reference another plan, we'll have to reference two separate plans in the decision.
Well, the plan
It
that was
just-
submitted.
It gets, Jerry, I understand what you're saying, and I know you're trying to ease the situation, but if somebody simply wants to finish off an area, and they think there won't be any issues with the board, it's very easy to get on the docket in a one-night decision, say, that's great, 10 minutes, everything's fine, it goes.
But then it takes 29 days afterwards, just like if this thing doesn't get signed tonight, which it won't be, might take a week to two to sign, there's another 29 days. This particular case, we're butting up against construction season, and I don't know
No, I know.
if you could get
So-
to this.
That's
So, no,
the-
that's,
the
So
process
as,
with
so
every
as an open,
application, though.
so as an open meeting now, you're having a presentation, the addition by the applicant is completely unfinished space. So every abutter and neighbor assumes now that that's what it is, that's what they changed the plans for, they changed their application.
I don't know what every abutter, because I don't know who's come in. We haven't received any. I think we're being presumptuous. Well, first of all, I think maybe most of the board disagrees with me, so we should just end discussion. We could just have nods ahead. I just think, in good governance sake, we try to make this streamlined without impeding them or impeding us. We don't need more things in front of us. He's got enough catches that puts accessory apartment in, someone's gonna blow the whistle. He can't do it anyways. Building commissioner won't allow it. We have to trust the building commissioner. By our own zoning regs.
I do have,
I know we've had issues so far with that.
Wait a
so-
minute, that's immaterial. You're saying, we're not gonna allow cars in front of a school because someone might speed, even though we have a speed limit. What's in front of us, do we trust the other departments to fulfill their duty as we fulfill ours? The building commissioner is the inspectional services person. He has the responsibility to ensure compliance. And we not here to overlook him to say, oh my God.
So the
Has he
appli-
ever approved an accessory apartment that we haven't seen? I don't think so.
So the application before us tonight is for a 30 by 36, unfinished, unheated space.
And I'm saying we
And,
can
and,
make,
and what we make our decisions on is what is submitted to the board and what's submitted into the file.
but he has submitted oral testimony to say, or he's agreed, what I understand, if he puts nothing more than one bedroom, not to exceed, he doesn't make an accessory. You can run down a list of laundry lists to protect what we think might happen, which is fine.
If he submitted a plan right now. of what
Doesn't
he
have to submit a plan. He just has,
If he did,
did.
if he
Jerry,
went
I
by,
think you
But
had a
Jerry, what's in front of us is the unfinished drawing.
a good idea. Let's see if anyone favors what you're.
well, that's what
talking
I asked 10 minutes ago.
I personally feel that it's customary, when we have a special permit, we ask if there's alterations, they come back, yes. We can't anticipate exactly what might be done, and in order to protect abutters, I've always felt it's important.
That's true.
That we have that as an option, so that they will have an opportunity to comment on any new project.
Okay.
It's not that burdensome.
Right.
I
agree.
As has been said.
If I may, I do have a build-out here that I'd be willing to stipulate to, if that'll assuage
I
your
think,
concerns.
I very much appreciate what the proponent did here. They did what we asked. They provided proof that they can fit the appropriate size septic system on. They modified the plan to show it as unfinished, which is what it currently is going to be. To me, that's good enough.
What about the build-out that he'll stipulate?
Well, when
He could do it
look,
tonight.
either they're doing it or they're not doing it.
He's just saying it might be done. If it is done, he wants permission to do it, according to that, and I don't even know what's on that
It
plan.
will be done at a future time, I just can't
Right, so when
guarantee
it's
how
done,
long it's
come
going to
back
be.
and we'll approve it.
It'll take 10 minutes and it'll be done.
Fine with that.
Yeah.
Okay. So go on with your condition, Bob. I think you
Well, I think that would just be the decision in the future. If they decide to finish it, they submit plans to the board for review prior to the application for a building permit. Also need to condition it on any of the engineering comments that came in regarding
Sure,
the new driveway and drainage.
All right.
So our usual,
The usual, and there's a
no
couple-
modification, any modification, no matter how minor.
Any modification, no matter how minor.
Yep.
And then they can notate the engineer's comments that we have submitted to the file.
All right, so I think that might do it for conditions. So that was a motion to approve by Jerry and second by Ed. All those in favor?
Aye.
Do we have an idea when this might be signed? I'm sorry, I'm sympathetic to people that are coming to the end of a building season right now. So for 2 weeks and 29 days, and it's up to you. If you can't do it in a week, you can't do it. I don't know what your workload is.
Yeah, we get them done as soon
Only
as we
within a
can.
week, Jerry.
Within a week, okay, all right. Within a week, they hope to have the signed permit.
Okay.
But then you have 29 days or whatever the stipulation is after that.
Thank you very much.
Thank you.
Thank you.
And should we get back to MEWAD?
Yeah, Mr. Maroney's here, so maybe we can go
Very good.
back. So we'll reconvene 20-19, MEWAD 213 and 0 North Falmouth Highway.
Good evening.
Good evening.
Nick Marioni here for the applicant, Joe Moward. And I have a letter, I suppose it's the, qualifies as the financial analysis for the information we submitted regarding the nitrate system, the denitrification system for the septic. And I'm puzzled, so I can't really interpret it, Noreen. I haven't had time to really digest it. If you want to please tell us what the conclusion is on it, I'd appreciate that.
Well, I'd rather not recharacterize what the consultant just said.
Is the consultant here to speak on it?
Yes,
Oh, great.
she was here,
She was here,
yes.
not here any longer.
No.
Then I'll do my best to interpret it. It apparently supports my argument that the denitrification system would adversely affect the profits on the project. You looked at the consultant looked at it looks like 3 options. Each one of them reduce the profit on the project to below the 15% that Mass Housing likes to see as a minimum. I assume you're looking at the same thing I'm looking at? The-
Yeah.
So, I guess based on this, I'd like to ask you to make your decision on the waiver request that we submitted with the application for the waiver not to have to provide a denitrification system.
If we've gone through the other stuff, we're gonna take this out of order because it's, I mean, we have to approve the system and then approve the individual waivers, right?
Right, we don't have a motion right now to vote on.
No.
But, I mean, we can certainly give you a sense of how we feel.
My discussion is, I think,
Or do we have any questions, I should say? Do we have any questions for the applicant right now?
I just have
And then
one
we can
question,
get
and
to
it
discussion.
doesn't have anything to do with the pro forma. So you increased the square footages on the units. Did that change the dimensions of the foundations at all, or just the unfinished space?
It adjusted them, but it didn't increase the overall size.
Was it just the roof line change in the back? Is that where the difference came from? On the second floor, originally it showed lofts.
We increased the amount of second floor space above the first floor space,
Okay,
yes.
but it didn't affect the actual
No.
envelope of the project?
No.
That's all the question here.
Any other questions for the applicant?
I don't have any.
Anyone on this side?
no. I'm assuming you don't know the type of denitrification system or anything else they were talking about.
I don't, this says, it says Cleaned 2 LLC. I think that's a company. I've
That's a
never,
consultant.
and also the Buzzards Bay Coalition. I don't know what systems they were using.
Yeah, it doesn't actually, in our document doesn't indicate that, actually, by name.
I guess I'll start off. I didn't do well the last time. I think we should grant the waiver.
Oh, we're not to discussion yet, Jerry.
Oh, I thought you, oh, I'm sorry, that we
No.
were.
Any other questions from the board? Any questions, comments, concerns from members of the public? Anyone out there? Had a couple of hearings. If you want to make any comments regarding the proposed denitrification or anything else that might be out there? Anything at all? All right. Back to the board. Guess we could have discussion before we do anything.
I guess I'm leaning to approve it based on the information that was, to approve the waiver that was submitted. I think it wasn't as definitive as I thought it might have been. They're referencing West Falmouth Highway demonstration projects. Those, all of them are not approvable by the state yet. And I'm not sure that these would be approvable. I think we can ensure nitrification, or denitrification, that when this watershed has a TMDL defined for it, this project will have to meet the then standards that are developed by, well, the Water Quality Committee as approved by the town and the state. I mean, right now, we don't know if this is 10, 12, or 14, which are all good systems. But God forbid if it comes back that they have to meet 12 when these systems only have 14, and the Board of Health says, okay, with 14. So, I mean, that's why I don't think it's tremendous risks, other than it could put some added cost on the affordable units. And I think that's always the case when you have affordable units with other units. Costs for the whole development could go up. Unless they can put in a reserve based on this, on potential increase in cost for on-site advanced system, which is going to occur in the future. That's my comments.
Any comment?
Well, I mean, we asked for an independent consultant, and they provided us with information that I think does support the developer's point of view.
Yes.
You said that better than I did.
Anyone else?
No, I agree with Ken.
No, I agree. If the figure goes down to 15%, then it's uneconomical. We can't go below that.
Mary, anything? And I tend to agree. I think as a basic concept, it would have been nice if the numbers came in and if it would have worked out. This was a good project for it with the shared septic.
Yeah.
But the numbers just aren't there, so. But we do remain hopeful that perhaps there's a
Oh, they
project
were
in the
gonna get
future that
Yeah.
could incorporate that.
I think people would disagree. I think the numbers aren't there, and I'm not sure the technology is there for a shared system. Because I think there's another project that might have gone the other way on recently. And that's my observation based on my experience. That the numbers aren't there and the technology is not definitive enough.
And would we like to have a discussion about the project as a whole prior to closing or continuing?
I think we have, I about all the information we're going to get at this
Yeah.
point.
I think we've beat it to death.
I don't think there's any outstanding issues, are there?
No, I mean,
No.
This was the last one.
Yeah.
you know, it comes down when we do conditions or anything, but that retaining wall way in the back, so where unit number 5 is, borders the lot of Paul and Paula Hennessy, and I know that retaining wall is large in the area. I would like to see as much screening as possible on that section, to screen that one property, because it is so close to the lot line, and they weren't, we had asked them originally if they could move some of the project towards the town of Falmouth land that was conservation area, but they said that they couldn't do that. And because of that, I think it would be important to just get as much screening as possible behind those units. Again, due to the retaining wall and how close they are to that specific lot line. You know, I know most of the other details we get eventually anyways, the really fine details, so that's just something that I'd...
Anything else regarding the project?
What were the other waivers he requested? There's only a couple, if I remember correctly.
There's a long list. I mean, in all likelihood, what would be best to do
Yeah.
is, once we close the hearing, and if we make a motion to approve, ask the administrator to start drafting.
Yes, that's a good
positive
idea.
motion
Positive
Yeah.
motion.
Yeah.
for complete review to the board, and then at our next hearing, we can discuss in detail the actual decision,
I think
and then
Yeah, I
vote
think
the
that's good.
decision.
that's the way to go.
Yes.
So then I make a motion to close the hearing.
Second?
Motion to close by Bob, second by Ed. All those in favor?
Aye.
Aye.
And then I would make a motion to approve with conditions and to ask that the administrator draft a positive decision for full review of the board members to discuss in detail at the next meeting.
All right, is there a second?
Second?
Okay, so that motion was made by Bob and second by Jerry. All those in favor?
Aye.
Aye.
So the next meeting will be on
Seven?
November 7th.
November 7th, so you should state that you're gonna begin deliberations.
Okay, so beginning deliberations. Should we modify that motion?
You can just announce that
All
that's,
right, so the next, we'll take that up on November 7th. Deliberations, reviewing the positive draft of the decision.
And I just want to let people know that I won't be here on November 7th, so hopefully Mary can be here.
Yep, she was
It's my 50th anniversary. I have other places to be.
Congratulations in advance.
Congratulations.
Do we need because we were gonna vote it, do we need any kind of
Don't look
extension?
old enough.
All right, so we're all set November 7th for review of the positive draft.
Thank you. Night.
Thank you.
Can you actually vote on that?
Yes.
Yeah.
All in favor? I thought we... Did we vote?
I don't-
I don't think so.
We did.
Okay.
Yeah.
Do you want to do it just in case?
No, why not?
We have all sorts of
All right, so
open
that-
meeting stuff going on.
The motion to direct
Continue to
Noreen.
November,
Con-
so the motion would be to direct the administrator to draft a positive decision to be sent out and reviewed by all the board members for discussion and vote on November 7th.
All right, and the second was from Jerry? Jerry, that was the second? All right, so the motion was made by Bob and second by Jerry again. All those in favor?
Aye.
Aye, all right. Now it's official. Okay, up next we have application 39-19, 797 Main Street LLC, which is 797 Main Street in Falmouth.
Good evening, Mr. Chairman, members of the board. For the record, Hal Chuba, Consulting Engineer with offices at 112 State Road in Dartmouth, Massachusetts. I'm representing the applicant on this application. At the last meeting on November 3rd, I know Mr. Dugan had some questions about the delivery and the size of the vehicles and the turning radiuses on the site. He also had some questions about the reciprocal easement agreement between my client and the adjacent property owners, both to the east and to the west. So I do have a couple of options for the delivery. I did send the email this morning to Ashley. I do have 5 copies of those plans with me here. Also, and I also have an email from the, I'll go through the emails and go through the plans, and I'll to the board and explain what the changes are.
If you don't mind handing that to Bob, you can stamp it in. Thank you.
Yeah, thank you.
I'll start with the plans. I do have two options as I indicated, and I have the board, I also have the plan on the board here, you can see it. And so basically on this layout, as I have indicated at the last meeting, we don't anticipate large vehicles to be doing a delivery on site, you know, and most of the delivery will be done in the morning hours before the restaurant is open for business. So most of the parking spaces on site, the 28 parking spaces that we have, will be available. On this option, you got a delivery, and I use the largest delivery, anticipated largest delivery truck, and I have the truck detail on the upper left corner of the plan, and that's a 30-foot truck. So I do have the template showing that truck can get in, back in, and get out from the same way that he got into the building, or this is one option. I do have another option. I know Mr. Dugan indicated that with the cars parked on Cycle Avenue on the east side, there might be a conflict with the, so I do have another option here showing that the delivery vehicle can maneuver around the entire site, and that's another option. So either way, we'll have those delivery vehicles into the site and out of the site without using Main Street for loading. And I had indicated also, if the board feels more, you want to include a condition on that we do not use Main Street for loading, we're not opposed to that. Also, there was a question about if the agreement, if the reciprocal easement agreement covered the property on the west. And I did indicate last time that the owner of Falmouth 815 Main Street, which owns the bank, also owns the other property at 871, I believe 781 Main Street. That's the bait shop and the Hogs and Dogs. Also, there was a question about whether Cycle Avenue is a public way or a private way. And also, there was another concern about access through Cycle Avenue to the parking lot to the south, to the Island Queen parking lot. I did talk to the owner of the property, and he did send me an email last night. I did forward the email to Ashley, both emails. I'm going to, you have copies of the emails, but I'm going to read the emails for the record. And this was addressed to me. It says, Mr. Chua, this letter shall serve as a confirmation that Falmouth 815 Main Street LLC is the owner of Cycle Avenue and adjacent property currently leased to the bait shop and Hogs and Dogs. So we established that it's the same owner. So the reciprocal agreement that we have covers the property to the west, and I think that was one of your concerns too, Mr. Dugan. Recently, Cycle Avenue was cleaned up from brush and dead small trees to provide better parking and visual improvement to the site and visitors. Cycle Avenue have always been privately owned and used as mentioned above. So he tells me it's a private, it's part of the property. It's also has a deed that they reference on the reciprocal agreement, easement agreement. I hope this satisfied your question and the Board of Appeals. Should you have any questions, additional questions, please don't hesitate to contact me at any time. And he signed it. He's the general manager of Falmouth, Lee Jamal, general manager of Falmouth 815 Main Street LLC. then he sent another email, because when I talked to him on the phone, I also wanted to touch on the issue of Cycle Avenue to the east and the easement to the back. And he says, the easement currently in place with your client does not in any way affect the cross easement with the Island Queen, which we have nothing to do with that anyways. Island Queen could only access Cycle Avenue from a gate, which have been installed by Island Queen years ago. In addition, the easement with your client does not approach on the easement with Island Queen. So the gate is there. If they need to access their property, they can do it. Nobody's blocking it. We have nothing to do with it. You know, the agreement is to park in the rear to the south, with 9 parking spaces will be available to us at all time. And after business hours, when the bank is closed, we'll have another 7 parking spaces. So that was the agreement, and I mentioned that the agreement was also approved by the planning board. The site plans were approved by the planning boards. The agreement was reviewed by town council, and for the record also, we had 3 public hearings with the planning board, and we all know with the public hearings, this is our 3rd meeting with the zoning board of appeal too. So if anyone had concerns from Island Queen or abutters owners, I would assume they would be here tonight or at any time when we had a public hearing. So I think at this time, I'll be glad to answer any questions, but those are the answers to the questions that you had. And
So have you read the easement agreement?
yes, I did.
So the initials on the easement agreement, I assume, is from this owner and the owner of 815.
Correct.
So do you have anything from town council that said they've actually reviewed this agreement? Because there's a lot of errors in the agreement.
I know the planning board wouldn't approve the site plans and the agreement until they have an agreement. The only change that they wanted, I guess, at the bottom, which I'm not sure if I have a copy of it, but I'm sure Maureen, you can talk to Tom, and he has a copy of the agreement, that they added the Town of Falmouth Planning Board next to the Barnstable Registry District of Land Court. Other than that, if you refer, I'm not sure what kind of.
So in general, so if you just reading over it, and I'm not an attorney, and I don't pretend to be one, but they start off referencing the LLC that does own the adjacent properties. Then they drop the name of the LLC and they just reference 815. The issue is 815 is the bank property, it's not the property on the other side. So it starts to get confusing of which property actually has easement rights. They've got a dumpster placed in here that says it's 12 feet by 18. I know that's an error, I know it should be 8, but they've signed an agreement that says they can put a 12-foot by 18 dumpster on Cycle Avenue. The biggest issue I have, and we have not heard from town council, is that Cycle Ave, although it's owned by the same LLC, is a separate lot. It's a separate deed, has no structure on it, and it just shows as a road. It's listed in the town's street maps. I don't know if the current owner had the right to turn it into parking to be able to lease you parking, because they would need a permit for a parking lot. Even on that strip, they would also have to notify the assessor's department. I've dealt with some of this in the past on other things, and usually they abandon the road, and it's usually an application they do to change it. But I think what might have happened here is that somebody bought the property and decided that they needed extra parking for an adjacent parcel and created it. There's nothing in here that says that the easement access to the Island Queen Corporation only is on where the gate is located. The Island Queen owns the fencing area. It may just refer to Cycle Ave as a whole, which means they could move the gate. They could move their entrances. You've got a situation where the bank property at 815 has labeled all of that parking currently as bank parking. So he's actually made a decision to make that bank parking. Then on your plan, it references in here that these 6 spaces to the west, which is that bait shop area on that side lot line, are actually for use of those businesses. It doesn't say you have the right just to use those spaces. but I don't think there may not be legal rights right now to use Cycle Ave as parking. And what they did at the back of the property is the parking spaces go perpendicular, they cover the entire width of what was then the road. So there is no space for anyone to go through on Cycle Ave at all. And he also created spaces on the other side. So what I was trying to find out, and I know you're not the owner of that property, they're just trying to give you an easement to lease it, is where is his permit that he was allowed to turn Cycle Avenue into parking? Because it's a separate deed. The assessor's department sent us information that it's separate deed, same owner, but separate lots. So that was my biggest issue with Cycle Ave. Can they use it for parking, even to lease it to you? And if they can, where is their permit? When did they do the work? When did they pave it? I live in an adjacent area. I used to go back there all the time. So I understand what his description of cleaning up is, but I used to cut through there, and that's not what I used to observe back there. I think somebody needed parking and they created it. I just don't know if they had the right to create it, and that will probably affect the easement agreement. Now, if the town did review the easement agreement, even with the planning board, there should be something in the file that says town council has reviewed and approved the agreement. But knowing town council, if I can go through here briefly and mark up 10 to 20 errors, it just seems unusual that town council would have looked at it and said that this matches what your plan is. So I understand it's not, you're just trying to lease the space. I just don't know if you can, because I don't know if he has the legal right to turn it into parking. And I do see where you changed that close in at the end.
Yes.
You did add that in, which
Yeah.
is great. When you use those side spaces, those side 4 spaces for the adjacent businesses, does that deduct from your parking spaces? The count? And it also says in this easement agreement that other building, that 7, I don't know if it's 781, but where the bait shop is, it says in this agreement that they can, without any acceptance from you, relocate their dumpster and do changes according to this agreement. So I just want to make sure that's allowed, and from all the information that I've been able to get through the file, through the assessor's department, that it's a separate deed, there is nobody that said that can be used at all for parking, or did somebody do changes to the lot without a permit? And if it can be converted to parking, what is the process? Do they need to abandon the road? Do they then have to notify the abutters that have easement rights? Do they have to change a layout? The assessor's department would then have to assess them as a parking lot, not assess them as a way access. So those are all the questions that I think need to be answered. I know you've tried your best to get the information from the owner of 815. I just don't think the owner of 815 has given you the information that we need. So town council may have to weigh in to see if that owner had the right to do what he did originally. And then once you redesignate those spaces, I know it's a separate application, but does now the bank have an issue because now the bank has lost parking? Because according to your easement agreement, the spaces on the other side that the bank's using on that entrance are also to be used by the building that has the bait shop and the hot dog company. And then they can just access over your property. So I don't know if that's information you can get or if town council's gonna have to get it, but I would wanna see that before doing the permit. I did think it was unusual that on the planning board decision, that they made a notation in a decision that I've never seen before. Let me pull it up for a second. They made a notation in their decision that if there was any change to that easement agreement in parking, that they would have the option of either removing usable space out of your first floor or removing the first floor. And if they're writing that in there, they must be concerned with something that could change parking, and I don't know what somebody would do if you open a nice restaurant, a nice business in there, and then there's some kind of a change, and suddenly the planning board says, there's 800 square feet of your restaurant that you now have to X off and you can't use for anything. It's an unusual piece of their,
Right, no, I think the permit was for 44 aggregate seats, regardless whether indoors and outdoors.
no, I know, but
That's
their
what was the
notation,
agreement for.
they're worried about the easement agreement. And their notation is if there's ever a change in parking, that they would either remove portions of the first floor, remove it, or they would have portions of the first floor that you could not use as a business. And I've never seen that in a decision before. I don't know why it was in there, and I don't know why they put it in. But we don't have an answer to that either, and I'd be interested to see why they were worried that something may change. And if something changes and they have a permit for a business, and I assume you'll do a booming business once somebody's open in there, that someone is literally gonna walk in and say, because we know there's a change in parking, we're making you take out half of your first floor? It just doesn't make sense to me. So I'd like to get information from town council on that, but I need a final decision on the road. Is it allowed to be leased to these people as an easement? If so, it's fine. If not, and they want to proceed to do that, what steps does the owner of 815 have to take to first change that area into parking so that he's allowed to lease it to you?
Ed, any questions?
No, that's plenty.
With regard to 240-108C, which is the loading requirement, is there a point on this map where there's a dedicated spot?
We discussed this before, no, I mean, you require a 20 by 40 space, I think 20 by 40 or 20 by 45, I'm not sure.
Yeah.
So, yeah, so, I mean, for the size of this restaurant and for the type of business, I've indicated that most of the delivery is gonna be in the morning, where most of the, I mean, I can stripe one of the parking spaces, but then we lose a parking space, but then again, we'll be back into the same, not having the 28 parking spaces required. But, I mean, this plan, site plan review, we went through with planning board for multiple of reviews and hearings, and, you know, so it's either, if this is the board, we probably would ask for a waiver. I mean, that's the only, or we say that we can use the parking spaces for delivery during the non-business hours or something like that, you know, so.
I just read it in our bylaws as a requirement, so.
Yeah, me too.
Were those side spaces, those 4 side spaces, in the count for the spaces that were needed?
Yes.
So if they designated them that they wouldn't be used for this business, that's a question. If they're relooking at the easement agreement, having those spaces reserved for a business next door when you need them for your seating, it would probably be better if those were reserved for you.
Anything, Ken?
Well, just a clarification, you've given us, I missed this. You were talking earlier and I was trying to assimilate it. We have 2 versions of the plan?
Two options of,
Options.
no, it's not 2 versions. It's 2 options for delivery. You can either pull in from the main driveway, which is in the northwest, and drive all around, drive to the back of the building, park in the parking spaces in the back of the building. That's where the delivery is, the back, you know, there's a door there. Most of the deliveries will be by vans, I have indicated, but yeah.
But there's nothing different about the plans except the way you've shaded it to show how the.
No, that's what we discussed. I think Mr. Dugan indicated that he wanted to see the largest vehicle with the delivery and the turning radiuses. You know, we did mention that we can't meet the 20 by 45. That will take 2 parking spaces. We're already, you know.
You could request, I'm not sure exactly where you are in the parking requirement, but you know, often people request a parking reduction.
Again, I think parking reduction, if I recall, I think it's the planning board that can give up to 10%.
25, right,
Tw-
yeah.
25, that might be, it. Yeah, well, I mean, we go back to the planning board and ask for the, I mean, the idea here was this is a business redevelopment lot, so the intent is to reuse the lot in a way that you put your parking in the back, and if you need a reduction, they're open to this. But when I went to the first time to the planning board, they're all uptight about parking spaces again,
Of course,
and
the
I,
idea
you know,
behind
so.
that was that you could have shared parking with adjacent businesses.
Absolutely, that's what they encourage, and this is what we have exactly. Now,
Right,
I'm
so
not
that-
sure, I mean, we go back and forth, but I'm not an attorney, I'm not into the easement business, so I can't answer those questions.
But I do share the concern that the chairman has, which is, my reading of the bylaw does not say this is something that we can waive. You know, it says off-street loading requirements, and basically,
It's come up in some previous
all
plans.
spaces, it says for every building and structure that receives, ships, loads, or distributes material or merchandise, there shall be maintained on the lot adequate space for standing, unloading to avoid interference in public ways, and then it says, all spaces shall be 14 by 45 feet. Not giving us latitude, unless I'm misreading somehow.
I guess the only way you could get around that is if they gave the size of the largest vehicle at 30 feet, you could do a smaller space that could fit the 30-foot vehicle, but you'd still have to have a space for the 30-foot vehicle. Like, I think on the car wash project, they had a similar situation. They gave us the same thing, a vehicle size, but they put in actual parking space for that vehicle, and then we just conditioned it that that's the largest delivery vehicle that can go on site and sit in the.
I'm not sure we didn't take liberties there, but.
They might have.
I think we did.
Yeah, we might have taken liberties.
I know we didn't.
Anything else, Ken?
That's it.
All right, Jerry, anything?
No, I agree with you and Bob. The one thing I notice is we didn't get anything from the steamship authority saying they agree with that interpretation of the easement.
On the steamship?
Oh,
Yeah, Island Queen.
Oh,
That might be kind of minor, but if they're going back to,
Don't get those two confused, they're not the same.
and that's just, you know, it's, if we get all the other legal stuff straightened out, maybe the board doesn't care if the Island Queen agrees with.
No, and the Island Queen may not, they may not even have an option to agree or not sometimes with an easement. Sometimes it just states this is the
Excuse
area
me,
that must be
they're not
clear.
part of the easement.
You know, it just, it makes, as long as their rights stay the same and they could get in and out, I know you're gonna get an
Okay.
issue with that, and I'd love to see the project permitted correctly. I know there's an issue with a separate deeded parcel that's a road to just pave over it and turn it into parking.
And a follow-up on the loading.
sure.
It might be unorthodox, but given this is business redevelopment, is there any consideration that if they deliver early, they live park and unload, and they're not taking the loading zone is also a couple parking areas?
It depends.
It's a dual-hatted loading zone that's used for parking, because they'll get deliveries in before 6 AM, and no one's gonna be parking there.
I guess it just
that's just a
depends,
question
I guess
for
it
the
just
board.
depends on the leeway, but the problem is, like Ken said, it's very specific measurement-wise on the, it's telling us on a main road what's
So we could-
required.
We could say shared parking is shared, the
Loading.
loading zone
Shared
is
delivery
shared
zone.
Well,
with the,
I'm trying to find a way
Parking
through.
for the-
Yeah.
Because it's becoming an issue on Main Street. It's just more and more, all the trucks get bigger, nothing gets smaller.
certainly, don't want block Main Street.
But do we like the idea of a shared loading zone with parking? I mean, he has to know whether he's gonna go
Yeah.
back and go back in front of the planning
Yeah,
board.
but I think the point is, it has to be shown somehow as, to meet the requirement.
Okay. It's up to him to see. Okay.
That's how I read it.
I'm not disagreeing with you, just see if there's,
I mean, I can show a parking space, maybe make it a couple of feet larger in width, to, I mean, we've taken some of the landscape out, which was fine, but we have plenty in the back anyways, but, and then there'll be shared parking space and loading. So, like you said, in the morning, if they come in, they can unload, and then if it's available for after, maybe we can put a sign not to park between certain hours or something. I mean, if,
I guess, see if the other members of the board sort of agree with that type of compromise. Once we see it solidified. Again, I hate to see it go back to the planning board, reduce parking, and, you know.
What do you think, Bob?
I don't know, I think you just need to show a space somewhere. I think
Right,
you're gonna have to show a space, whether you use it or not, maybe they just drive through, but you need to show the space.
It's an interesting suggestion, that, you know, there'd be some signage, the space be
Yeah.
shown.
You just block it off
be
in here.
striped out, all that, but indicate that
Reserved for
during-
deliveries.
during non-delivery hours, somehow that could be used for.
right, it has to be counted for the for parking though, because otherwise we'll be in the,
Well, on the easement agreement, on the parking spaces in back, you have written in there that there is no overnight parking. So all the vehicles must be removed at the back of the lot according to your agreement.
Mhm.
So maybe if, when the vehicles aren't there, you could use that space as a, it's all gonna depend on what you can do with that avenue. Maybe the Island Queen will let you drive into their lot, and then you could park there.
You can't get through that gate. Last time I went by there.
you can't drive through, I mean, there's a difference in elevation and the I mean,
Telephone pole.
yeah, so it's not,
Bunch of stuff there.
I think the only issue you have with that is there was a court case on it. So they had a court case with the previous owner.
right, but we have nothing to do
No, no,
with
it has
that
nothing- it
section,
has
you know,
nothing to
it's
do
not in the agreement, it's not an issue, it's not,
No, I just mean it has nothing to do
Right.
with you, but Cycle Ave was a court case between a previous owner and the Island Queen, so.
Oh, okay. I understand.
Well, I mean, from my perspective, I can make the changes on the plan that we can satisfy the loading with the parking space. But as far as, I can't go further with the Cycle Ave.
That's
And
not
I
your
really
control.
don't want, you know, I mean,
You need them to give it to you.
So
Right.
I don't know whether they're gonna give it to me or not, or if you wanna refer it to town council, by all means. I mean, I can't, you know, we've been going back and forth for the last, you know, honestly, we're gonna miss the construction season for this, you know, for the winter, you know, and unfortunately, it's, you know, the site is not in the best, you know, this is a nice project and
It's
in-
unfortunate. that-
in the, you know, and with the intent of the redevelopment business. We did everything that we were asked to do within that district.
I know you
but-
followed all the rules and regulations. I
So-
think it's very unfortunate that you went through a site plan review, and site plan review never questioned when they have a separate lot that names it the street, and they deal with this all the time, to say, we need this information in advance, so that when you came here, you wouldn't have to worry about it.
Do you have, because I guess I don't think I can repeat it, do you know exactly what Bob is referring to when you come back? You know, legal review cleaned up, is Cycle
legal
Ave been
review,
allowed?
yeah.
I mean, if we can get some bullet points
So
so
we can
that,
touch base with Frank, with town council,
yeah,
to see if he's even looked at the easement agreement, and if so, have him review it.
okay.
Have him give us an opinion on the Cycle Ave, and if the current owner can use that as a parking lot.
Okay, that's
Did he give
specific,
easement
yeah.
out
And the loading zone.
in a loading zone?
Just
Because
add it to
the
the
Cycle
drawing.
Ave stuff is out of their control, it's a.
The loading zone, if you want it striped, or I'd probably just not stripe it, just call it loading zone / parking, so it'll be,
Drawing.
so we can
On the drawing.
reuse the number, exactly, you know, so we don't,
I don't think that has to go in front of Frank or town council.
No,
No.
and the
No.
only other thing, if they work out whatever happens back there, you're gonna have to figure out how to put signage up that's not on the property next door. Because right now, he's attached all his signage to somebody else's
Well, they put that down in conditions.
info.
All right, so we're looking at another date. Which is,
so just to be clear, from here, for plans, I only have to provide you with the loading,
The loading zone.
right?
So Also, can he draw the where would be the loading zone on the plans so that you have that?
Right.
That it would essentially still remain striped for parking?
Yeah.
And that maybe you would limit deliveries to be prior to the building opening?
Right. That's what we'll probably do.
What's our next available?
7th and
We
the
have
21st.
November 7th and November 21st.
First.
You think the 7th gives enough time?
Frank's got to do the work, right?
That's what I mean, yeah.
Yeah.
I guess it depends what
It's 3
the
weeks.
attorney
almost,
comes
right?
back with, right?
And I guess we could always go with the 7th, and if he needed more time, he could let us know in advance, and,
7th is 3 weeks,
Yeah.
right?
so why don't we do that? So I'd make.
Available the 7th?
7th.
Sure.
Okay.
Would anyone like to make that motion?
I'll make a motion to continue this to the 7th of November.
Second.
Motion made by Ed and second by Bob. All those in favor?
Aye.
Aye.
Thank you.
Thank you.
Thank you.
Okay, up next, we have application 42-19 Hawks Warma, 641 West Falmouth Highway in West Falmouth.
Do you have an extra copy of the letter you sent?
Do, but I might need to steal it back if I have to refer to it.
Then I won't scribble. That's okay. Go ahead.
Good evening, Mr. Chair, members of the board. For the record, my name is Kevin Clower. I'm an attorney with Ahmet Clower Law Firm here in Falmouth, and I represent the applicants Arthur M. Hawks and Sarah Warma, the owners of 641 West Falmouth Highway. As you know, we're proposing to remove an existing non-conforming garage and shed and to construct a single-family residence at the rear of the lot located in the Residential B zoning district. Following our last hearing, we did reach out to town council, as this board requested, in order to review the memorandum that was prepared by the assistant town council. We reached out to them early last week. They were unable to meet last week. I was told to reach out again on Tuesday, which I did, and provided them some correspondence regarding the memorandum. And we had planned on meeting this morning, but weather interfered with that because no one had power or could get anywhere. So I have not had a chance to sit down and review the correspondence I submitted with town council. I'd like to go over that with you guys quickly, and there's also kind of a separate avenue that I discuss in that memorandum that I think this board can act on. As I noted in the letter to town council, we respectfully disagree with the conclusions found in their analysis. Attorney Mullins' memorandum correctly states that the more restrictive portion of a lot can't have active prohibited uses. What we're proposing in the residential B district is a single-family use. The actual active use within the residential B district is a single-family use, which is allowed by right within that district. The Tofias case, which we've discussed, I think, at length, states that uses made in the more restricted district are allowed, provided they're not inconsistent with the requirements of that district. So here, the use of the more restrictive portion of the lot, the residential B district, for a single-family residence is clearly not inconsistent with the requirements of that district, as it is an allowed use. Assistant Town Council also referred to a case by the name of Harrison v. Braintree, the building commissioner of the town of Braintree, which is really about a separate matter, but I think is easily distinguishable from this proposal. In that case, the owner of a split-zone lot sought to create an access road across the residential portion of his lot to serve an industrial plant on a different portion. The court held that the use of land in a district where all aspects of industry are barred for access to adjacent industrial plant violates the residential requirements. This board and town council has explored that exact question previously, specifically in the Fieldstone condominium approval at the corner of Westmoreland and 28A. And in that case, the applicant was putting access to the multifamily portion across the residential portion. And the rationale in that 2001 decision has value. And I quote it in the letter, and it says, based on a memorandum from Town Council Frank Duffy Jr. to Town Planner Brian Curry, the board finds that access across the residential portion of the property may be permitted by special permit, as the Code of Falmouth allows multifamily dwelling use in a residential district by special permit from the Board of Appeals and Planned Residential Development. In cases of lots split by district boundaries, the use of land in the more restrictive district, residential, as access to land in the less restrictive district, business, is prohibited if all aspects of the use in the less restrictive district are prohibited in the more restrictive district. Town Council opinion at that time was that the residential B portion did allow for multifamily by special permit. It's an allowable and permissible use. And the zoning board and town council used that to justify that approval and other approvals of this nature. And as I noted at the last hearing, there were some details that were omitted from that analysis, specifically that there were existing non-conforming structures, which were the basis for the application under 243C. The garage, which we're proposing to remove, is 5 feet from the side yard line where 10 is required. And the shed, which is over 100 square feet, is only 3 feet from the side yard line where 10 feet, at least 10 feet is required. I know this board felt that they struggled going against what town council had said in that memorandum, but the zoning board is entitled to a reasonable interpretation of its own bylaw. And such interpretations are given deference in doing so. While town council's opinion is certainly important and a matter that should be weighed, when it removes the discretion of the board, seemingly, it's something the board can overlook if they choose to do so. That portion I just went over addresses really the memorandum that was presented by town council at the last meeting. All of this said, if the board agrees with that analysis, under the present iteration, I think that there is another avenue of relief that the board could grant. If town council's opinion is correct, and the proposed active rather than passive use of the entire lot would be multifamily, then as it stands, the current active use is a duplex. A duplex is allowed in the Business 3 district. It's not allowed in a residential B. However, in this instance, we have the garage providing parking for that duplex located entirely in the residential B portion of the lot. That would constitute a non-conforming use of that portion of the lot. This board could grant a special permit under 243C for an alteration of a non-conforming use, provided that you find it's not substantially more detrimental than what presently exists. This is the same logic this board has used to approve a number of special permits along this nature. 4 Old Dock Road being the Ideal Spot Motel, the Westwind Condominiums at 597 West Falmouth Highway are 2 projects within about 300 feet of this that were approved on the same basis of an alteration of an existing non-conforming use. This board can grant a special permit. It's within your discretion to do so. We believe we've given the board a number of avenues where they can get to that. We want to get there. We don't really care which road we take. So if the board doesn't feel that they can, at this point, disregard town council's opinion in the last memorandum, which we have provided, I think, a substantial amount of information that the board, that town council can reconsider and the board can consider. If the board doesn't want to overlook that, then you can certainly grant a special permit for an alteration of an existing non-conforming use. The end result of this is a good project which is restrained in its design and requests. It's complementary to the neighborhood, and it's in line with the surrounding properties. It meets the standards of 243C, 240-51A5, and 242-16. I think this board can and should grant the special permit, and I'd be happy to address any questions that you may have at this time.
Thank you, Attorney Fowler. Jerry, would you like to start us off if you have any questions? We can always come back to you.
Well, I think I like the avenue where we don't have to necessarily disagree with town council, because we haven't had a chance to view town council's opinion of your opinion. And the alternate, if it's, and I'll defer to some of the more senior members of the board, that we can grant a special permit for existing non-conforming uses, seems to put it in favor of, well, I guess I'm making a statement. I'm sorry. I have no questions.
All right. Ken?
Yeah, can you just clarify for me, what is the pre-existing non-conforming use currently on the lot?
So the parking serving the duplex is located entirely within the residential B portion of the lot. Much like you couldn't have parking for a business in a residential portion, which is a non-allowed use, a duplex is not allowed in residential B. So because the parking serving the duplex is entirely within the residential B, this board could find that to be an existing non-conforming use. And that the alteration of that non-conforming use to multifamily is not substantially more detrimental than what currently exists.
And are you, I don't remember the plan well enough, are you
So if you,
taking that,
this garage is proposed to be removed.
removing that portion of the parking to a
This garage will be removed entirely.
Okay.
And then this single-family house will be constructed. So the garage is to be raised and the single-family house is to be built.
So where's the parking for the duplex now, just on the plan?
So there's, I mean, they could certainly park here if they chose to. And there's,
Like you're saying, there's parking currently in the residential B? So where is that?
so the garage parking serving the duplex is located right here, which
Right,
is
so
in the
so
residential B.
So the parking that's currently, is so like inside the garage, so if you put in
Yes,
the garage.
yes.
I think that's helpful.
Good.
No, I don't have any more.
Bob?
No, I think it's an interesting idea. I'd just like time to review it,
Yeah, I wish you could.
because I think we're in
We do need to get,
a bind on split zoning, so.
Well, I think if you want to take that approach, you have an existing non-conforming use, which can be altered by special permit, and that's true whether it's split zoned or not split zoned. I agree, I think there's a question over split zoning lots. I have other clients with these questions coming up that I don't really know how to advise them on it right now. But right now, in this particular instance, which is the one I'm concerned with in this moment, we have a non-conforming use that the board can choose to grant a special permit on under 243C, which is something they have done consistently, or something you have done consistently for other uses of this nature.
so, I mean, we have a big agenda tonight. My feeling is we had asked to get this clarified between the two attorneys, they were unable to do it.
we need to
Unfortunately, there was one
And
this morning.
I think we should just keep going. And, I mean, you've made an interesting argument, which I'm inclined to be in favor of, if we can get the assent of town council.
My only issue with that is town council's not a voting member of the board.
I understand, but they are giving us a legal perspective that, you know, is important to us.
Sure. I think that this could be
I'm not saying
approved.
we couldn't totally disagree with them
Mhm.
under some circumstance, but we did seek their advice.
Sure.
And we have not yet gotten a resolution. We were hoping you guys could talk.
I'm still inclined to speak with town council about the outstanding questions, just as a matter of knowing what it is moving forward. That being said, I think that this can be granted without having to address those particular questions at this time, because we're providing a different avenue of relief. And it's still a special permit under
That would be the
243C.
interesting thing to explore with town council also. Because based on what they wrote, the original proposition doesn't fly.
Which is a question that can and should be addressed just for everyone to know moving forward, but I think this particular permit can be granted without getting to those questions. And I think in fairness to the applicant, and if the board is inclined to do so, and views it as within their discretion to do so, that they can and should.
I have a tendency to agree with Ken, that it would be nice if.
We're
we knew
almost
what-
there.
If the attorney said, we agree with your alternative approach.
And because this just came up tonight too, it's kind of a quick,
Right.
and I think it might work too. I would like to see them be able to do something there. The neighbors are very in favor. I think they did all the right things, getting everyone on board. I think we just got backed into a corner on the split
But
zoning.
you see the danger of doing something and then having the precedent set where you come back to us in 5 years with another project and say, oh, but you approved it before.
Sure, I mean, understanding every project's different, and I know I've said that you have approved other ones of this nature in the past, and you have, fairly consistently. And I think that the questions that were presented to town council don't have a bearing on this particular avenue of relief.
But town council had some insights that were actually, I thought cleared up this uncomfortableness
Yes.
I've always had with this particular, the decisions you cite from the past.
Sure.
Were,
Does anybody object? I think you might, just trying to see if we can move forward. We recommend a draft approval, subject to town council agreeing with the alternative approach. You're shaking your head, no?
Well, my issue is, as it
Okay.
stands right now, town council disagrees with the project. And
No, I mean,
if
subject
not
to
for
them.
the act of God this morning, we would have had the,
No, I understand
answer.
that, but it's sort of like, it's iffy, just saying if town council agrees, then it's approved.
My
They
only,
don't.
my only issue I have with that is that it's just that this just came up now, and
Okay,
I haven't been able to look at a plan, and I think it really could work. I need more time to review it.
okay, I just,
We just got this morning, right?
No, this we haven't seen, this is,
This is the same plan that's been presented.
no,
It's not
but
the plan.
this
Yeah.
idea,
Yeah.
this
it's not
just
the
came up
plan,
now.
it's
Sure.
just the
when did it
legal
just-
argument.
I thought it came in 2 days ago.
No, the plan's been in, nothing, there's,
Yeah.
The legal argument,
my memorandum to town council was sent on Tuesday, and
it's kind of short too, though, but,
well, I mean, I had been trying to meet with them early last week.
okay, I guess.
Understandable why you weren't able to do it today, but I think we could fence with this quickly if you can do it before that.
Yeah.
That was the one thing we asked for, was to get some meeting and resolution.
I reached out to them last Monday, and on Thursday was told they can't do it.
Blaming you.
Well, I mean, when you say it's the one thing we asked for, we've
But
tried.
I guess what I'm trying to convey is that I think we are in the same place we were before. We don't have that bit of information.
My only point is I don't think you need that information to
I understand you
provide
feel
that.
that way, but we did feel that we needed that.
I think the board at least disagrees temporarily, right? We think we need it.
I think
Yeah.
we need it.
Well, Attorney Clower, you're certainly an advocate on behalf of your client tonight. And you've heard from the board that we've even said this is a good project if it can be approved. We just need town council's opinion. And we also received very complimentary letters from abutters, which I did read earlier today, so.
I
I'm not
am,
saying it's a bad
Yep.
project, we just. wanna
so
make
what
sure-
would we be looking at for the next date? Because I've heard 2 things move to the 7th already.
Can we move it to the 7th?
It should be straightforward.
Should be very
It shouldn't
straightforward.
be
Very
long as a-
straightforward.
Hey, could we start at 6 instead of 6:30? I
We
know.
could.
Yeah.
I'm not here on the 7th. I can see if
Oh.
Bob can cover it. It's not my 50th anniversary, it is my 10th. So,
40 more to go.
I'm working on it, all right? So I can see if Bob can cover it, and that's what I was just speaking to my client about. So if the board can put it on the 7th, that's great, and if Bob
We
can't
can put it on
cover
the
it.
7th, and then if you find there's a problem with it, just notify. the
We'll let you know
office
right
as quick
away.
as possible,
Yeah.
And we can move up to whatever the next date
Yeah.
is.
21st.
Yeah. So I'd make a motion to continue to November 7th.
Second it.
Okay, motion was made by Bob and second by Ed. All those in favor?
Aye.
Aye.
All right. Thank you.
Thank you.
Thank you.
Okay, so up next, we have application 26-19, Ketchadorian Ballas, 5 Canapisset Drive in East Falmouth. And I also see that an identical appellant with 18 Tashmu Drive, it's application 63-19. If we could perhaps make a motion for 6319 out of order and open it with 2619, that might be appropriate.
So start with 2619?
We could open them,
16.
make a motion to take 6319 out of order and open it with,
6319 out of order and take it together with 2619? Is that what you're suggesting?
that is what I'm
Yeah.
suggesting. All right,
I'll
so,
make that motion.
thank you, Ken.
Second it.
Thank you, Ed.
So neither of these have been opened yet, so I'll read each one individually just to get them into the record.
So we'll get the vote. So it was, motion was made by Ken, second by Ed. All those in favor?
Aye.
Okay.
So first application number 63-19, being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Mass General Laws, you are hereby notified that Michael Cachadorian and Stephen Bayless of East Falmouth, Mass. have filed an appeal with the Falmouth Town Clerk pursuant to Mass General Laws 40A, Section 8 and 15, and 240-202 of the Code of Falmouth, appealing inaction of the building commissioner and requesting zoning enforcement regarding placement of 2 floats on subject property known as 18 Tashmoo Drive, East Falmouth. On that one, as far as referrals, Concom attached to Chapter 91 license. Planning board, no comment. And that's all we have on that one. And now application 26-19.
That's an appeal, right?
Yeah, but we've extended this one like 4 times. So application 26-19, being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Mass General Laws, you are hereby notified that Michael Cacciadorian and Stephen Bayless of Falmouth, Mass. filed an appeal with the Falmouth Town Clerk pursuant to Mass General Laws 40A, Section 8 and 15, and 240-2 of 2 of the Code of Falmouth, appealing the inaction of the Building Commissioner and requesting zoning enforcement regarding placement of 2 floats on subject property known as 5 Cannapitsit Drive, East Falmouth. Concom comments. 5 Cannapitsit received local approval in 2012 and installed 2 4-foot by 20-foot. A request for determination of applicability was approved by the Concom on 6/13/2012. Did not receive approval from the Board of Selectmen, and no record of a Chapter 91 license from DEP Waterways. And then planning, no comment.
Okay, and for the applicant tonight?
Good evening, Mr. Chairman. My name is Brian Wall. I'm an attorney with the firm Troy Wall Associates in Sandwich, and I represent both of the applicants tonight, Stephen Bayless, who's with me here in the audience, and Michael Cacciadorian. As you read into the record, these are appeals of building commissioner inaction, and so our contention is that it's a de facto denial of 2 requests for zoning enforcement concerning neighboring properties. The questions that are presented to the board tonight are relatively straightforward, I would assert. The first question is whether the floats maintained by the 2 neighbors at issue violate the zoning code because they do not have the benefit of special permits under sections 240-77 through 79 of the Falmouth zoning code, which are normally issued by the Board of Selectmen. And if so, whether the floats must be removed until such time as these special permits are obtained. I did submit letters to the board on each application, and I'm not going to go through them, but I'd like to go through a little bit of the factual background because I think that it will put the questions into context and will explain also why my clients are seeking the enforcement. I forgot about the screen, so I brought the old-fashioned board, and I couldn't figure out the easel, so forgive me. But let me just give you a little background of the area. There's a man-made canal over off Muskeget Road that was originally constructed prior to the Wetlands Protection Act in the late 1970s. And my client, Mr. Bayless, looks like Mr. Potemus might have figured it out for me. Mr. Bayless owns lot 64, which is this lot on the terminus end of the plan. And Mr. Cacciadorian owns the neighboring lot to the north, again on the end of the canal. The canal extends out to Eel Pond, and there are 4 other properties on the north side and 4 other properties on the south side of the canal. Over the years, the property owners who have lived on the canal have put in floats to make it easier to access their boats. Mr. Penticus, who's at issue, had put in 2 floats, each 4 feet by 24 feet in size, to which he ties 2 different boats. Should I give it a try, or?
I can't get any higher than that.
That will help, though, I think. Forgive me. Thank you very much.
Ryan, the releases are, the releases are on the bottom.
Okay, thanks. I think this will work then.
Certainly better.
Yeah, that'll do. So, As I was saying, this canal, it's surrounded by a cement bulkhead that was put in before the Wetlands Protection Act. And Mr. Penticus lives to the north, so this is his property here. And the blocks that are shown in red are the 2 floats that he has in the water. Again, 4 feet by 24 feet in size each, and he ties 2 different boats to the floats. The other property owner that's subject to this application, this appeal, is Mr. and Mrs. Dundulis, who live down here on the south side. And at the time that this dispute arose, Mr. and Mrs. Dundulis had 3 floats in the water, each 8 feet wide by 20 feet long. But now currently, which are shown again in the red outlines, and currently they have 2 floats, 6 feet by 16 and 6 feet by 20. Everything seemed to work fine in the canal over the years until the very last vacant lot, which was right here, was purchased by Mr. Cachadorian in February of 2017. He wanted to build a house on the property, and for obvious reasons, he wanted to have a float or a dock like everyone else on the canal. So he sought out the advice of a local engineer, and that engineer informed him that in order to have a dock or a float, he would need a state wetlands permit, a town wetlands permit, a special permit from the Board of Selectmen under the zoning code, and a Chapter 91 waterways license from the DEP. So given the existing floats on the north and on the south, Mr. Cachadorian was informed, and also because Conservation Commission requires 3 feet of depth of water at the end of the pier to have where you put your prop. So it was decided to meet these regulations and to fit it into the canal. The most appropriate design was to build a perpendicular dock, which is shown here in brown. And what Mr. Cachadorian did was he knocked on Mr. Bayless's door and said, "This is what I'd like to do." And Mr. Bayless at the time had a float here outlined in black, which was 4 feet by 24 feet as well, that he had actually obtained from Mr. and Mrs. Dundulis when they got their bigger floats. And he didn't have proper permits for that either. And so the 2 of them decided that they would engage in the permitting effort together to go forward. And so what they did was they filed with the Conservation Commission to obtain wetlands permits. And when they went to the hearing, I didn't represent them at the time, but I've been informed that many of the neighbors came out, and under the wetlands bylaw, the local wetlands bylaw, navigation is one of the issues. And the neighbors complained that if the dock were built and boats were berthed on each side, that the neighbors would have difficulty getting to their floats and their existing floats and their existing boats. Essentially, they thought that the dock would impede their ability to use their floats. Despite that, the Conservation Commission granted a local wetlands permit and a state wetlands permit, and Mr. and Mrs. Dundulis promptly appealed those permits. They later dropped their state appeal, and the Superior Court affirmed the decision of the Conservation Commission and upheld the permits, but now that is on appeal to the appeals court. Nevertheless, Mr. Bayless and Mr. Cachadorian decided to press on, and so they filed for a special permit with the Board of Selectmen. And again, the neighbors appeared and made the same arguments about navigation. However, between the commission's hearing and the selectmen's hearing, Mr. Bayless and Mr. Cachadorian did some research, and they discovered the following. They discovered that Mr. Penticus, he has that request for determination of applicability that was mentioned when the comments were read, but he has no special permit from the Board of Selectmen, and he has no Chapter 91 license. So our contention is basically that his 2 floats don't comply with the law because they're not properly permitted. Similarly, Mr. and Mrs. Dundulis, they have a Chapter 91 license for the 2 floats that are shown in brown. So those are properly licensed by the state, but our research indicates that they don't have a special permit from the Board of Selectmen. So it became clear from this research that the neighbors' arguments in our contention were essentially kind of a false argument, that they were saying that this dock would impede access to their existing floats, but their existing floats are not lawful floats. They're unlawful floats. Furthermore, as you can see, as a matter of fairness and equity, Mr. and Mrs. Mr. Penticus has 2 floats with 2 boats, and the Dundulises have 2 boats with 2 floats. But they were essentially saying to the Board of Selectmen in so many words, we want to keep our 2 floats and our 2 boats, but we don't want you to have your dock or your boat. It was a very contested hearing. It was continued over 2 nights, and the selectmen ended up voting 3 in favor for the special permit, but 2 against. And as the Zoning Board of Appeals, you know that to get a special permit, you need 4. So the motion failed to carry and the permit was not granted. However, the Board of Selectmen made a clerical error, and they did not file their decision with the town clerk. And as a result, Mr. Bayless and Mr. Cachadorian filed for a constructive grant. And so they actually have their zoning permit for their dock as well. However, Mr. Dundulis and this time Mr. Penticus filed an appeal, and that appeal is now pending in court. But what's become clear to my clients is that in order to resolve this situation, they keep going forward following the rules, getting the permits that they need, but they keep getting shot at essentially by the neighbors saying that we want to keep our floats and we don't want you to have your dock because it's going to interfere with our use. And we think the only way to really move this process forward is to have everyone go through the permitting process that they're supposed to go through. We're not seeking to deprive Mr. Penticus of any floats or Mr. and Mrs. Dundulis of any floats, but we do want to get, my clients want to get their dock with their floats so that they could have the docks. Essentially, what they're looking for is a level playing field, to have the same rules apply to everyone and to go through the same process so that the Board of Selectmen can decide on how to equitably allocate use of the canal. Because under the zoning bylaw, when one puts a float or an object into a tidal body, it triggers the application, and the selectmen have authority to decide on what's appropriate. And we think that if we go through that process, so the selectmen in their wisdom will decide on who gets what, and everybody can go about their business. Mr. Penticus is, I think he's here tonight. He's represented by Attorney Glenn Wood of Rubin Rudman up in Boston. And I've been in communication with him over the past few months, and he wrote a letter today that was submitted into the record. He agrees that his client needs a special permit, and he has said that he is going to file for that within the next 90 days. Mr. Penticus's hearing was continued a number of times because we've been trying to resolve things, but it's on tonight marked no further continuances. So I told Mr. Wood we're very happy that his client has decided to file, but I felt that I could not withdraw this appeal because it would potentially prejudice my client's rights, and I'm not disparaging Mr. Penticus, but if circumstances change and for some reason he didn't file for that special permit, I would have dropped this appeal. So, however, he is saying what we're asking for is a ruling that the floats don't comply with the law and that they have to come out of the water until they do comply with the law. And Mr. Wood has asked that if the board agrees with this position and makes these findings, to essentially suspend the removal order for 90 days so that they can stay in the water while Mr. Penticus seeks the permit. And my clients have no objection to that. You can see from what I said in my presentation, this has been going on for quite a while, and we're not trying to be heavy-handed, we're just trying to get that level playing field that I talked about. Mr. and Mrs. Dundulis are also represented by counsel. I've been dealing with him, I think, for the past 15 or 18 months on these cases, and I see that he's here tonight. I'm assuming he's going to oppose this. I just want to state for the record before I turn over the podium that I did ask for him to give me anything that he's going to submit to the board tonight, and he didn't give me anything, so I don't know what he's going to say, so I'd like to reserve some time for a rebuttal. And with that, I'm available for questions.
Okay, any questions? We'll start down on this end. Mary, anything?
I don't.
Bob?
So yeah, a couple questions. So the floats, when they are allowed, aren't they seasonal?
They are, and they're seasonal by I think not only the Chapter 91 license, but I believe the selectmen, as a matter of practice, usually requires them to be seasonal.
So where they're seasonal, when are they usually removed? When is the removal season, and when do they place them back in?
I don't know if the Chapter 91 license says exactly that, but I would submit that the Conservation Commission usually wants them out by, I think, November 15th and not in before April 15th. It's usually the boating season, and that's usually what recreational boaters insurance usually requires too for,
So if it was November, we're almost at that point now where they would need to be removed.
yes.
On the Pennicus, according to you, their counsel is here, they'll be speaking to us, but they've agreed to go through the process with the Board of Selectmen, which is the only thing they need, correct? Just the Board of Selectmen?
Right, so their counsel's not here. He wrote a letter.
Wrote a letter,
But I think
they
Mr.
just need Board of Selectmen, in your opinion?
He has a pending Chapter 91 license, which also, I'd like to bring up a point about that. That's one of the matters why we're here as well for enforcement. I neglected to mention this. In order to file for a Chapter 91 license, there are many things that are needed, but one of which is a sign-off by the building commissioner that says that the proposed floats and dock comply with zoning. And the building commissioner did in fact sign Mr. Penticus's application, even though there's no special permit. So I somewhat diverged. Your question was, is there anything else needed? He needs to have a special permit from the Board of Selectmen, and he needs to get that Chapter 91 license.
And as far as the Dundulas,
So similar answer, they also have, they have a Chapter 91 license.
but you said they don't have one with the Board of Selectmen, but yet they do have a constructive grant, so.
No, we have the constructive grant. So we have, for our, let me just,
You've got the constructive
yeah,
grant for that, though.
if
That's why
I
I'm
may,
getting
just
confused.
for purposes of clarification, I can see there's some, it's very
Yeah.
complicated. So Mr. Penticus, he filed what's called a request for determination of applicability, which the Conservation Commission made a determination that he didn't need a wetlands permit. And he is using that to get his Chapter 91 license, but he has no Board of Selectmen zoning permit. That's why we're here for zoning. My clients have a state wetlands permit, town wetlands permit that's in the appeals court, and a constructive grant of a selectman's permit, a 3-2 vote, but they got a constructive grant. Mr. and Mrs. Dundulas, I couldn't find any wetlands permits on record, but they have a Chapter 91 license for these two brown floats. In my presentation, what I had said was, and I think that their attorney will say this, but when they purchased the property, I believe that these two floats were in the water. And then subsequently, I was informed that Mr. Dundulas was able to buy these 3 larger floats from Nantucket, I think. He brought them over and then gave this float to Mr. Bayless, that's what's here. And these 3 big floats were in the water when we were before the selectmen. And when we were trying to make the case that all the boats can fit, but Mr. Dundulas was arguing it will interfere with his floats, which were the big ones at the time. Those have since come out, and now these brown ones are back. But the point we're here about tonight is neither Mr. Penticus nor Mr. and Mrs. Dundulas have a special permit for the floats.
So where you say under Dundulas they purchased it, is that why the Chapter 91 license is under the name of Augusta?
Correct. It was, the Chapter 91 license was obtained by prior owner. And if I may, you didn't ask this question, but in anticipation of something that's going to be said, our contention is that Mr. and Mrs. Dundulas do not have a special permit, and that's based upon 2 things. One is, I did a title search and I couldn't find one. Now, if I stand corrected, I'll have to stand corrected. But under Massachusetts Chapter 48, Section 11, if you don't record a special permit, it doesn't take effect. It has to be recorded in order to take effect. So there's no special permit on record. There is a special permit for the bulkhead. And so what happened was, the bulkhead was built before the Wetlands Act came into play. And some of you might remember, there were many instances all over the Commonwealth where people had built things into the water that required Chapter 91 licenses, but they didn't have them. And so in the 1990s, the state DP had an amnesty program that basically said you can come forward if you need a permit, you're not going to be penalized, you're not going to be fined, but file your permit and pay your fee and go about your business. There's a amnesty license for this bulkhead, and in the process of getting that amnesty license, Mr. Augusta filed with the Board of Selectmen for a special permit under 240-77, which is the section at issue, and got a special permit for the bulkhead. And I've included all these materials in my letter. They're all consistent. The application was for the bulkhead, didn't mention floats. The public notice was for the bulkhead, not floats. Comments from various town officials all were based on the bulkhead, not floats. The permit doesn't mention floats. And so there is no special permit for the floats. There is a special permit for the bulkhead.
So where there isn't a special permit for the floats, so they have an attachment with the license, book 53650, that shows floats.
It does, yes. And how they got that, I don't know, because as I mentioned a minute ago, in order to file for that Chapter 91 license, they needed a sign-off from the building commissioner that the proposed structures in the license are approved under the zoning, that they comply with zoning. And I don't know how they did that without the special permit. But what I can tell you is, as far as the chronology goes, they filed for that amnesty license, and what they did was they went to the Board of Selectmen and got a special permit for the bulkhead, and then shortly thereafter, they got that Chapter 91 license. And on the plan for the Chapter 91 license, it shows the bulkhead and it shows these two floats. So they have a Chapter 91 license. We're not contesting that. They do have it. However, they have never gone to the Board of Selectmen, and they do not have a special permit under Falmouth's zoning code.
Thank you.
Ed, any
Nothing,
questions?
nothing.
Ken?
Okay, so just, I want to be clear what you want right now, because that's somehow, nice explanation of the situation. You'd like us to actually not do anything at the moment. Is that correct?
No, so there's two appeals that are being simultaneously heard because there was this overlap of facts.
So for one of them, you want us to do
So
nothing.
for both of them, we're asking the board to make a finding and a ruling that the floats maintained by Mr. Penticus and by Mr. and Mrs. Dundulis require a special permit under sections 240-77 through 79 of the Falmouth zoning code and do not have such permits, and therefore are unlawful. And then the second part of it is we're asking that the floats be removed until they obtain such permits. That's what we're asking for. Now, as far as Mr. Penticus,
Excuse me, one sec. So Penticus has CONSCOM approval, but not the selectmen, not the zoning approval.
he doesn't, correct, he has Concom, he has a determination. He does not have Chapter 91, and he does not have Board of Selectmen. And it was his attorney that wrote the letter that said,
But he's pursuing it.
he said that they're going to file for a special permit, and what he's asking for is, if the board does decide to agree with this and overturn the inaction by the building commissioner, to suspend that removal order so that Mr. Penticus can keep his floats in the water while he's seeking the special permit. And my clients have no objection to that because, again, they're looking for the long-term solution here, which is to have everybody file with the Board of Selectmen and go through the permitting process.
But you do not want it to be suspended for the Dundulis situation.
Correct. I don't think my clients are heavy-handed. If Mr. Hoyt gets up and says that they agree they need a special permit, but they want some time, we would have no objection. The key part of what we want is to have them go through the permitting process out of fairness and because it's required by the law. And we think that once everyone goes through that process, hopefully there'll be a solution arrived at after some hearings before the Board of Selectmen.
I think I got it.
Thank you.
No questions.
And no questions from me either at the time. So any other follow-up questions from the board?
No.
All right. Any members of the public have any questions, comments, concerns regarding these two appeals?
Good evening, Mr. Chairman, members of the board. My name is Drew Hoyt. I represent Frank and Patty Dundulis, who own and have lived for quite some time at 18 Tajmu. I do have materials to provide, and I apologize for not having gotten them to Attorney Wall earlier, actually. I was, like a lot of people, thrown off by the power outages all over the Cape today, and I was, had to haul back to off Cape to make my copies and so on. So, you've just heard a very dishonest presentation, and I'll explain why, and I'll show you why.
Could hand it in to Bob Dugan, our clerk, he can stamp it in. Hand it in to Bob, he'll stamp them in as the clerk.
So I'll just step you briefly through what I've just handed you and explain to you why I've said that you just heard a very dishonest presentation. The Dundulis' floats have a selectman's permit. It was issued in 1995, and a copy of it is immediately follows my letter. It's a December 21st, 1995 permit. References a plan of record dated December 18th, 1995, drawn by Christopher Costa and Associates. And if you flip the page, you see a copy of the plan that was submitted to the selectmen, that was in front of the selectmen when they issued their special permit. And you can see that it includes on it the 2 floats at the Dundulis property, and it includes the signatures of the Board of Selectmen. This is the plan of record referenced in the permit. If you flip the page again, you'll see Exhibit 2, a municipal zoning certificate, signed by Mr. Gore, the building commissioner, at the time at least, indicating that the project described above, which is described as 80 linear feet of concrete and sheet revetment with 6x20 and 6x16 floats, that the project is not in violation of local zoning ordinances and bylaws. So, the selectmen issued a special permit. They had in front of them a plan showing floats. Now, the plan itself doesn't, in the title of the plan, it's described as bulkhead. That's how that's how the project was described at the time in the plan. It wasn't described as bulkhead and floats, but it shows bulkhead and floats. And accordingly, the permit describes the project as a bulkhead, but the plan of record shows a bulkhead and floats. So, I said it was a dishonest presentation. I didn't say it was a mistaken presentation, which would have been my first assumption, having worked with Attorney Wall for many years. The reason I say it's a dishonest presentation is that when I went to the town hall earlier this week and asked for the file for the Board of Selectmen with respect to this permit, the town clerk said, "Oh, someone just was in here, got that not long ago." And of course, that was Attorney Wall, or someone, I assume it was Attorney Wall or one of the applicants. And they printed for me the exact same set of materials that was previously given to the applicant or their counsel. And within that package of materials was the plan showing the floats. So you might ask yourselves why that plan of record was not included in the materials submitted to the board by Attorney Wall, when he certainly had it. The presentation that was provided in writing and was given again was disingenuous in that it intentionally omitted any mention of the plan of record that shows the floats. So that should be the end of this request for enforcement, which is brought in bad faith, and for reasons I'll explain on that further. The floats are compliant. They have the necessary permit. They have a Chapter 91 license. They had at the time a negative determination of applicability by the Conservation Commission, which was a finding that no order of conditions was needed. That's all they needed. They are fully licensed and permitted floats. Further, you can continue flipping through the materials, you'll find an aerial photo. It's kind of hard to see, but I think you can see that at the end of the canal, at the Dundulis property, the two floats that we're talking about are pictured in this photograph, which was taken in 1994. So the floats were already in place when the Dundulises went to the Selectmen and the Conservation Commission and DEP to get all their licenses and permits. The floats were in place when the harbor master, in advance of the Selectmen's meeting on the special permit application, went to the site and inspected it. And the harbor master, came back and said he had no issues with the project. He didn't specifically mention the floats, but it is certainly true that he went out and looked at it, and the floats were there. The floats having been there since 1994, even if there had not been a special permit, would be grandfathered. But they're not. They don't need to be grandfathered because they have the special permit. They are fully permitted. I would like to further to the bad faith and dishonesty of this request for enforcement. In their letter to the board requesting enforcement, the applicants claim that they are aggrieved by the presence of the Dundulis floats. Looking at this plan, this is the applicant's proposed float document. They're going to do, if this gets built, take the boat, and they're going to pull in. How do the Dundulis floats, when the boat's on, impede the applicants? And they made no attempt to demonstrate that they would. In fact, in a moment of candor, the applicants have been pretty clear about what they believe their agreement is, which is that the Dundulises have exercised their statutory right to appeal and contest this proposal. Because in their view, while there's no reason to believe that their floats or boats would impede the applicants from using their float, the applicants just go straight in and back straight out. Whereas the Dundulises, if there were boats here, would have a hard time utilizing their floats. And on that basis, they've appealed this proposal. And that appeal, their refusal to roll over and let this thing go through, is the basis for the supposed agreement. The Dundulis is exercising their rights is not the basis for an agreement that would permit them to come to this board and claim to be aggrieved by the presence of the floats. That's what they would need to show. They would need to show that they are aggrieved by the presence of the floats, not by the fact that the Dundulises filed an appeal. What this is, what this application for enforcement is, it is an attempt by the applicants to leverage the Dundulises into either agreeing to their proposal or agreeing to some other arrangement more favorable than the one that the Dundulises have been willing to offer. And history here is that, as was mentioned, when the Dundaluses bought their property, these floats were here. And when they got so old to the point that they needed to be replaced.
Attorney Hoyt, I'll just ask you to use the microphone.
Oh, I'm sorry.
Especially for
Sure.
the benefit of
Sure.
those at home.
When the time came for them to replace those floats because they were just old and they were like, you know, your foot would go through one of them at least, right? They found some floats that they were able to get for a very affordable price. And they offered Mr. Bayless, who had moved in sometime after they offered him one of their floats that they were taking out, one that was at least in good enough repair for him to use. And he accepted. And he put his float there, still there, unlicensed, unpermitted, and sitting there. And he used that float for a number of years. The Dundaluses, to accommodate that, moved their floats further away from his bulkhead than their license told them to have it at, as an accommodation to him. And as Attorney Wall indicated, all was well. All was well on this side, with Bayless having a float here and a boat, and the Dundaluses having their floats pushed a little back away from his bulkhead. So the idea that Mr. Bayless is aggrieved by the Dundaluses' floats is ridiculous. The idea that he's crowding the dock or trying to deprive him of having one float while they have two is ridiculous. The Dundaluses went out of their way as good neighbors to move their floats and give him one of theirs so that he could have a float for his boat. And this is the thanks that they get from their neighbor. It's outrageous. And it's dishonest.
I think we're getting a little bit personal.
No.
You can say you have a disagreement.
Okay.
But dishonest, you mentioned it 2 or 3 times.
Well, I say that
thought other
because
people would say it. I don't think you should use the word dishonest.
Well, I'll tell you why I
With
think
our
it is.
procedures.
And whether
I asked the chairman for a ruling on that.
Oh, all right.
I agree with you, Jerry. It is strong language, especially in applications such as this, but.
It's irrelevant to the main point, which is that the Dundaluses have every permit they need. My point is that the same material that I've given you that demonstrates that was in the possession of the applicants. That's my point. And I'm not sure why it wasn't included in their materials. As far as what we would ask the board to do, we would ask the board to make a finding, number 1, that the applicants have no standing to be here requesting enforcement against the Dundaluses because they have made no demonstration that the Dundaluses' floats cause them any aggrievement or impediment whatsoever. They've been clear that what they think their aggrievement is the Dundaluses exercising their right of appeal. That would be the first finding we would request. The second finding would be that even if there were standing, the record indicates that they have the necessary selectmen's permit and there's no basis for enforcement. And third, if you were inclined to go that far, that even if that were not the case, the presence of the floats in the water for more than 20 years is sufficient to have them be considered grandfathered even if they didn't have a permit, so that there is no basis for this board to issue any kind of enforcement against the Dundaluses.
Thank you, Attorney Hoyt.
I had a question on.
Yes.
On claim 1, page 1, you said to be recorded in the bond tomorrow. In other words, this hasn't been recorded yet.
It was going to be
That mean-
recorded. The original draft of the letter said recorded today because I was on my way to the registry before I learned that they were closed for the day because of a area-wide power outage.
My point being, by it being recorded so late, what
It
does
is-
that have to do with the legality of the permit?
The case law on that is clear. It has, it needs to be recorded, but the fact that it is recorded, however late, is not of material effect.
Does it give someone grandfathering? Because if it wasn't recorded,
The case has, the point has been argued. The point has been argued and ruled on.
by whom? I'm sorry. I
Oh,
missed it.
I'm sorry, and I don't have the case with me. There's appellate case law that indicates that when a special permit is issued and acted upon, it is in effect for all purposes, provided that, when the issue,
Even though it's not
when the issue
recorded.
comes up, inevitably the thing gets recorded, taking care of that administrative requirement. But the SJC or appellate court's ruling is that the years late recording of a special permit does not prevent it from having gone into effect. That was
Okay,
the,
that's what you're
that is-
citing as case.
and I don't have the case citation. I mean, it's, I suppose, only relevant as with respect to the,
Okay,
but it will be recorded by tomorrow, and I will certainly send a copy of the recorded document to the zoning administrator, so you have it in your file.
It's a question for Noreen. We can't continue this? At the beginning, there was something, no ability to continue. I am assuming he is correct, but we haven't seen the case law he's referring to, nor has the other side, nor has town council. It may be very, very relevant, I don't know.
So it's not that you can't continue the cases, but we had continued one of the cases 3 times. So it then becomes a point of time where the zoning board could constructively grant something if you miss your dates on your continuances. So it's not a good practice to continue something without an end.
But we could continue if we wanted.
If I may,
I mean, I don't know what the attorney's gonna, maybe he'll agree with him about the,
if I may, I don't mean to interrupt. It's the applicant's burden to present materials to the board sufficient to justify enforcement. The applicant's materials have been incomplete, provided were incomplete, and if the applicant wants to make, if the board were to say tonight, no, we're not doing this enforcement, the applicant would be free to go back to the building inspector in the first instance with a package of materials that they may think better makes their argument if they disagree, and somehow are going to argue that, a late recorded special permit is somehow, invalid for all purposes. They could make that argument in their presentation to the building inspector. We could respond. You could get town council's opinion, and it could come before the board. There's no need to do that as a continuance of this hearing. The applicant has every right to make a better presentation than the one that it has made. And that's what I will say, just by way of background. The Dundulises have been, I think it's fair to say, very poorly treated by town boards in this case, in this particular respect.
I'd like you to not go there.
No? Okay. I would ask that you consider the history and the Dundulises having been.
Thank you, Attorney Hoyt. With respect to 18 Tashmu Drive, and Jerry, we opened up both applications, 5 Canapisset and 18 Tashmu. It's been 5 Canapisset, which was continued multiple times and finally opened tonight.
okay, I see what you missed.
18 Tashmu was just placed, if I'm reading the agenda correctly, it was just placed on the agenda tonight. And given the wealth of information that Attorney Hoyt has provided to us tonight, we would have to continue this to look things over, and I'm sure Attorney Wall would have a rebuttal to that information.
So maybe we should see if there's any other public comment before we.
Sure.
There is reference to the floats in the legal notice.
Okay.
96.
So with regard to both applications, any members of the public, any questions, comments, concerns regarding these 2 applications? Anyone at all? Sir?
We're gonna vote on them separately, though, obviously.
Oh, yeah,
Yeah.
yeah, yeah,
Yeah.
it's entirely
Yeah.
separate.
Good evening. My name's Tony Penticus. I live at 5 Canapitza Drive in East Falmouth. Kind of caught here with my pants down. About 2:45, I got a email and talked to my attorney. He said this was going to be postponed. And, you know, when you came up to the agenda, I saw what was going on, so I looked at some emails, and here I am. Yes, those 2 floats on the property were done with my parents, who owned the house prior to me. And it is correct, we went into conservation. We obtained necessary signatures, and we're allowed, I guess, to continue. And we had talked to Jennifer McKay after the application was signed off from all conservation members, and we asked if there was anything else we had to do, if we could put our floats in. She said, yes, you can put your floats in. So that's why a Chapter 91 permit wasn't filed, and that's why it never went in front of the Board of Selectmen. The bulkhead on the property was done that way. It was done during the amnesty program, so all necessary permits were done then. And we just figured with my parents that the quote-unquote, the bulkhead is in the water, and if anything happened to that, we know we would be responsible for any repairs to it. And the floats, okay, what's a float? There's a problem with the float, you pull it with the boat, you throw it on a trailer and take it out. But if something happens to one of these seawalls, it's a major issue. And I know I have to go for a special permit, and over the next month and a half, I'll be filing with the selectmen to try to get a special permit and go from there. And if Ms. McKay had told me and my parents back 8.5 years ago to say to go to the selectmen, and then from there, if they approved it, you would have to go to the state, like you did for the bulkhead for Chapter 91 license. Both those floats would be licensed. And to say this has been a disaster is an understatement for me and Dundulis's. And there were a lot of mistakes made by town members that affect town residents. And the financial burden is significant. The emotional burden is tremendous. And I think where people brush it away and don't say that or whatever, it's pretty hurtful. Thank you and have a good evening.
And you're represented by Attorney Wood, is that correct?
That's correct.
Okay. We're in receipt of a letter from him, and he is asking for a continuation on your behalf, so you can get the permitting through the selectmen and various town departments. Any other members of the public wishing to make any comments tonight? Any questions, comments, concerns regarding these 2 projects? Okay.
So, Mr. Chairman, just to be clear, so which of these has been continued 3 times? Actually, that should be apparent from the agenda.
So the first, so Canapitza
Canapissa.
is the one that's been continued. Tashmu was open.
So that's Mr. Penticus.
Canapitza was put on the agenda as
So
a
he is, although it's
continuation.
been continued 3 times, they are asking for further continuation. Is that correct?
Yeah. Their attorney's asking for 90
Okay.
days.
Well, in
to
that
get
case,
proper permits.
since it seems likely that we're going to want to also continue the Cachadorian Dundalis, why don't we just continue them both?
So I think one problem that you particularly have is that the Penticus request is to continue for some 90 days out in order for you to continue the hearing, you have to continue to a date certain.
Right.
That being said, you do not have a signed continuance. I did not prepare one for you for an extension for another 90 days, because you would have to have signatures from
Gotcha.
the
No,
applicant
that's
and
correct.
yourself. My suggestion to you is to continue to consider, granting a certain amount of time to Mr. Penticus, which would be at your discretion, and that you would close the hearing on that, and you give him an amount of time to pursue with the Board of Selectmen, and that perhaps to Mr. Wall's interest in this not being dropped, that you give a date certain, and that after which time, if the filing with the Board of Selectmen has not taken place, that you authorize the building commissioner to enforce. So I think that would satisfy your not picking a date in January that you're not aware of at this point in time.
But we could say up to 90 days.
You can pick your amount of time.
So would we actually be making a actual decision, and in the decision we're allowing them 90 days to get the proper permits to the Board of Selectmen, and then if those permits...
To apply, right.
Apply.
To
And
apply.
then, the Board of Selectmen will then make a determination, yes, you can do it, or what their decision is. So you just, because they do need the permit from the Board of Selectmen, not from you.
Yep.
So I think if you just direct them to do that, and you give them a timeline, I
And
think
it seemed
that-
like Attorney Wall that was advocating for that as well, so basically both sides agree on that.
And then I think regarding the other matter, you have a large amount of material that you've just received that you've not had a chance to review.
Okay. So should we dispense with the 6319 first, just by moving to continue?
Get two separate actions, right?
Right. This is,
So we continue for 90 days?
no. 6319 is the Dundalis one, correct?
Yeah, 6319
No.
is 18 Tashmo. That's the Dundalis at the bottom. That's the one we
Right.
got the information this evening.
Right. So that's,
So we could start with that.
let's start with that, because I think it's easy. We're just going to continue it, as Noreen is actually recommending that. I think, based on the amount of material we've got,
One of the things,
I'm not saying we shouldn't,
no,
if there's someone in the public who's here that would like to speak, that we shouldn't recognize.
Sir, if you'd like to
Right.
come to the podium.
Yeah, I'm Frank Dundulis, lived in
But-
Falmouth about 35 years. This is my third home in Falmouth, bought, sold. But with all our permits, we've been doing this a year now. What's another 90 days going to do?
Well, it gives us an opportunity to look it over.
Well, in your situation, you're the one at 18 Tashmo, so
Yes, sir.
we wouldn't need 90 days. We would just need to be able to review all the information that was submitted to us tonight.
Oh, okay.
The other one, which has been continued in the past, is the one that's requesting the 90-day extension.
Okay.
but we
So I misunderstood you.
Yeah, we're gonna have to do them
And
separately.
that's fine. I just wanted to
Well,
clarify.
Still need a Board of Selectmen to weigh in on that?
According to
According
the
to what
testimony, they have a
was
Board of
submitted.
Selectmen.
They've got copies,
Permit.
so...
Okay. Could we hear from Mr. Wall, since he was, I don't want to go into he said, she said, but
Neither do I, and it's getting late in the night, and we have plenty of applications to address. Attorney Wall?
Thank you, Mr. Chairman, Mr. Botemis. So for housekeeping matters, there's no opposition to us agreeing to an extension on Dundulis. In fact, I want it because I haven't seen what was submitted. I didn't even get a full copy. I got a letter and not some of those other things, I think. So we're not opposed to an extension of time to a date certain on 18 Tajmu, and I would also like the opportunity to review that, and if I feel it necessary, to submit some new information to rebut what was in there. On the Penticus one, the Kanapisset one. I just want to make sure I understood. That was on for no further continuances. My understanding about Attorney Wood's letter and my conversations with him were, he was asking in the alternative, he was saying, please continue it, and if you don't, and if you agree with the applicant, stay enforcement for 90 days. We don't have any objection to the second part of the request. We are seeking a resolution on this because if you look in the record, Attorney Wood actually wrote a letter a couple of months ago saying that he was going to file a special permit in 30 days. I'm not faulting him for that because I've been in conversations with him to try to resolve this matter, which I'm not going to get into. So I'm not saying that Mr. Wood misrepresented things, not at all. He, I think, intended to do that. We've been trying to work things out, but we haven't got there. But meanwhile, Mr. Penticus has a pending Chapter 91 license application that has a certification from the building commissioner that says he complies with zoning when he doesn't have a special permit. And so time is our enemy on that. And so we're asking for a resolution of Penticus, and we're not opposing a continuance to a date certain on Dundulis. That having been said, I'll be very brief because I know we've been a long time here. Let me just say this as far as the presentation that was made. I would submit to the board that when someone gets up and uses words like dishonesty and outrageousness and ridiculousness, they're trying to sway the board away from the facts. I mentioned before I yielded the floor that I've been dealing with Mr. Hoyt since the summer of 2018 on the litigation that I mentioned in my presentation. I copied him on my letters to the building commissioner. I copied him on my submissions to this board. He came in tonight and handed me these things that I haven't seen. He was in my office yesterday picking up documents that he dropped off last Thursday, and he didn't mention any of these things. But he comes tonight and attacks my integrity, but I would ask the board this one indulgence. If you look at the letter that I submitted on this, which is dated September 10th, and you go to the exhibits, Exhibit B is the application. Let me preface my remarks by saying this. The special permit that he's referring to, that he claims is the special permit authorizing those floats, is the same special permit that I'm talking about in my presentation. And very briefly, if you look at the exhibits that I've attached, the application was under section 4300. So the bylaw has changed. So if he goes to the registry tomorrow and records this permit that's from 1995, your bylaw has changed and he won't have a special permit under your current bylaw. But that point aside, the application has a line that says, describe the bulkhead, and then it says other, docks, piers, etc., not applicable. He's proposing to license the bulkhead. And as I mentioned, and I won't go through all of this, but the public notice says to license and maintain a bulkhead. The Board of Selectmen agenda says to license an existing bulkhead. The comments from the Department of Natural Resources was the bulkhead at 18 Tajmu Drive. The Selectmen's meeting minutes indicate the hearing was to license and maintain an existing bulkhead. So yeah, the floats are shown on the plan, but you know as the board that when public members get the notice, they look at what the person applied for. There was no application for floats. Maybe it was an oversight. Maybe it was intentional. I don't know. But the fact of the matter is there's no special permit for those floats, and I was not dishonest in my presentation. What we didn't see was Mr. Hoyt come in with a recorded copy of the special permit. And so as we stand here tonight discussing this, Chapter 48, Section 11 is crystal clear that a special permit does not take effect until it's recorded. So there is no special permit for these floats, and therefore I was not dishonest. I will reserve for my written materials, I will address the aggrievement arguments because my clients are aggrieved, and I can address the grandfathering too because I thought that might be an argument, and I have 4 arguments why it's not grandfathered. And I'll put that in writing and give it to the board prior to the next hearing.
Does aggrievement go to standing?
It does, yeah, the
Okay,
same
just want to
thing.
make sure.
Yeah, and I will address that.
So, Attorney Well, just one question. So in the packet that you just got this evening, there's a legal notice for the Chapter 91 license regarding 18 Tashmo, and that specifically notates bulkhead and floats.
And that's not disputed because I said in my presentation, they have a Chapter 91 license. So they came to the Board of Selectmen and they asked for a special permit for a bulkhead. And then subsequent to that, they applied to the Chapter 91 Waterways Department for that bulkhead and for the floats, and they got it. And there was a signature by Mr. Gore that said that zoning was complied with. But my contention is if you look at those, if you look at the paperwork, there's no special permit for for floats. Thanks for the opportunity to address that, because I didn't like it. Thank you.
Okay,
Thank
I'd
you,
like to
Attorney
make the motion that we continue 6319, and I await guidance from Noreen on the date
November 21.
until November 21, 6:30 here in Town Hall.
Second.
Okay, motion was made by Ken and second by Bob. All those in favor?
Aye.
Aye.
And that's the day before my birthday. I think they probably want to know.
Too much information.
And as
And
for...
I think for 2619, we could make a motion.
So I just, before you do that, I just have one question on 2619, because you're talking, like Noreen, you mentioned dates.
Excuse me, everyone, we're still conducting a hearing.
Are we able to Noreen, are we able to do just a continuation, or are we looking to do a decision
Oh, I
on
think
it,
decision
allowing
in
them
that.
90 days?
That's what I'm proposing.
I-
That's what I was going to move,
Okay.
was that we request enforcement in light of the fact that I guess they do not have currently a valid zoning approval through the Board of Selectmen, and give them 90 days to obtain that.
So I think what might be helpful would be to give them a 90-day period within which
90 days to apply. I'm sorry.
apply,
Yes.
I'm sorry.
and
You're
that
correct.
absent that application process being commenced.
We would request removal.
Enforcement.
Yes. Okay, so that's
So it's
my
90,
motion.
90 days from today or tomorrow, or? Want to make sure it's...
Let's make it from today.
So
I
your
don't know if
motion
you
then is for a 90-day period for them to make application, to get proper permits, and then if they're not able to get those,
If they're not applying, if they have not applied,
if they've not
It's not a-
applied,
because we don't know
Or
how long
denied,
that process.
right.
Or they, yes, or they're denied, fair enough.
then the building commissioner would need to enforce.
Right. I'll second it.
Through the chair, may I just make a point of order or clarification? I agree, I think that's a great motion, but I think that before you can discuss enforcement, you have to make a motion to either grant the appeal, because the building inspector failed to act and therefore denied enforcement. And so I think you have to grant the appeal so that there will be enforcement, and then the motion that was just made could be the second motion.
We probably also need to close this hearing, that's another.
That's true, we would have to close it.
So,
Thank
there's
you,
some
Attorney Wall.
procedural things, but that's where I'm headed with the motion, okay? So let's start with a motion to close.
Second.
All right, motion to close the hearing made by Ken and second by Bob. All those in favor?
Aye.
Aye.
And let's go to a motion to grant the appeal. I'm making that.
I'll second it.
So motion to grant the appeal, that was made by Ken and second by Ed.
But in granting the appeal,
Nope, that'll be the third motion.
okay,
Want it?
I think it has to be
Yes,
the
it has
same
to
one.
be.
Or does it need to be attached? I guess grant the appeal, but
Grant the appeal,
allow, okay, let's do it that way.
Yeah.
Grant the appeal, but we will
Allow 90 days.
allow 90 days for the applicant to
apply to the.
apply
Apply,
for
yeah.
proper permits through the Board of Selectmen under 240-70.
77
77, 89,
77 through 79.
yeah.
Yeah, and
And if the
if the
application
application
is denied,
is not made or if it's denied,
then the
we-
building commissioner will enforce the
Yeah.
removal
Okay.
of the floats.
Yes. Good.
Second.
Is that good, everyone?
Well said, Ken.
Yeah.
So that was the motion. Is it seconded?
Second.
Yeah.
Second by Bob. All those in favor?
Aye.
Aye.
All right, good.
Thank you very much, and November 21st for the other one, right?
Yeah.
Thanks for your time.
Do we need a continuation of time, or do we wait till then?
No,
Do we
we're
need a
up against it.
continuation of time?
We'll take a 5-minute break.
Yeah.
Let's do this continue to November.
You'd have to speak to Noreen, I'm sorry, we can't discuss the Okay, we are back, and thank you, everyone. We've had an unusually high amount of applications tonight, so thank you for everyone with these new hearings that we're moving on to. Just as a matter of housekeeping, it is 9:25 in our rules. We do close at 9:30, but by motion of the board, we can vote to continue our night. So would anyone like to make that motion to a certain time?
Make a motion, we continue to 10 p.m.,
All right.
Second it.
So
if not
motion-
longer.
Motion was made by Jerry and second by Ed. All those in favor? Aye.
Rapidly moving on.
Here we are.
Yes.
All right, so new hearings for the night. We have application 59-19 Pendleton, 18 Locust Street in Falmouth.
So being all persons deemed affected by the Board of Appeals, under Section 11 of Chapter 48 of the Mass General Laws, you are hereby notified that Paul and Ellen Pendleton of Falmouth, Mass. have applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C of the Code of Falmouth to raise and reconstruct the pre-existing non-conforming detached garage on subject property known as 18 Locust Street, Falmouth, Mass. For referrals, engineering general comments regarding dry wells, rain gardens, and containing all water on site. Concom, recommend controlling stormwater on property. Assessors, no comment. Planning, no comment. Historical Commission. The Historical Commission approved this at their September 3rd meeting. Once the decision is written, once revised plans are submitted, they will send it to us. Fire Department, no comment. Water Department, not applicable. And that's it.
Okay, and for the applicant tonight?
Chairman, board members, thank you for having me this evening. I am Paul Pendleton, for the record. I am the owner of the property at 18 Locust Street. I do not have an attorney with me this evening, so I'll be brief. I wanted to give you a quick history that, and it will be brief, that I grew up in the home. My parents bought it in 1961, and it's, as I mentioned, 18 Locust Street. It's in the historic district, right across from Grumpy's. You probably are familiar with the home, the red home there. About 8 years ago, I purchased the home from my parents, did a restoration on the home from afar, eventually was able to move home 3 years ago. Shortly after I moved here, we had a nor'easter come through and land on my garage, one of the trees, destroying it. So the time was to replace the garage, and the thought was to do something more culturally appropriate, or at least historically appropriate. And we, working with Longfellow, we came up with a design, and I think this evening, what we want to discuss really is more than the design is the, if I can get to it, go down. Oh, I'm sorry. I gotta, there we go. Is the discussion on the setbacks. The old garage is pictured here, and we're proposing a larger space, which would be much more convenient. The other one was pretty small, but the setbacks are, as with all the homes surrounding me in that area, about 5 feet from the parcel next to me. So it's 5 feet on this side. On this side, it's 3.9 currently, and we're proposing that we move it up and improve it by a couple of feet to 5 feet. But we don't want to push too far forward for a couple of reasons, particularly that we have a septic system right here that is, in this proposal, 13 feet away. So really, again, briefly, that's the idea. That's what we want to do. We think we have a great-looking building, and it fits the area, and it fits on the property as it did in the past, and as many of the garages similar in that area are set back on the property. I am open to questions.
Great. We'll start on this end. Mary, anything?
No, not at this time.
Bob, anything?
No questions.
I have one, just on the drawing, it calls for a bathroom vent. What, is there a bathroom in there?
No, there is no bathroom, we're not finishing.
One of the drawings says there's a bathroom vent.
If there is, we'll strike it from the drawing.
Okay.
There's no plan for any
I didn't think there was.
plumbing or,
Yeah, I didn't think there was.
right.
It's on the top of one of the sheets. Huh? Right here.
It says bath vent fan.
Proposed
Might be some
bathroom vent
ventilation.
fan. Up in the legend in the top of this drawing.
Pull it up on here.
Yeah. Sorry, for the record, James Bustamante with Longfellow Design Build. I'm just asking what sheet it's on. Maybe I just didn't.
A10. But maybe it's just in the legend, not on the drawing. Is it on the drawing?
No, it doesn't show on the drawings, but it shows it in the,
It's insulation.
A1, I think you said.
It's an A1. Might be in more than one.
This has a heat detector here, smoke detector here. I don't see the, oh, are you talking about up here?
It's in the legend.
Yeah.
Oh, in the legend, it's a copy and paste legend that we use.
Right.
It's, but there is no, yeah. So the legend is used here as copy and pasted onto plans. Those are the markings that we use. However, obviously, in these markings, we're only using a heat detector and a smoke detector.
okay, that's all.
To ask it another way, the proposed use is storage only.
Storage only. Absolutely.
Ken, anything?
Is it heated at all?
No, no heat.
Electrical?
Yes, electrical for lights, basically, couple of plugs for table saw stuff.
Anything else, Ken?
That's it.
Jerry?
No questions, it looks good.
Past improvement.
Thank you,
Yeah.
especially if you've driven by recently.
Yes, I did.
You don't have that much raising to do, mostly reconstructing.
think I'm just gonna kick it over.
All right.
Any other questions from the board?
Yeah, just real quick, so just for the record, when you did move it up, what was the original setback to the back lot line?
In the,
Because I think you improved it, correct?
yes, we improved it from 3.9 feet to
To 5?
3.5, 3.8. It's on.
Okay, members of the public, any questions, comments, concerns regarding this project tonight? Seeing none, back to the board.
Motion to close?
Second.
All right, motion to close made by Bob, second by Ed. All those in favor?
Aye.
And how would you like to proceed?
Motion to approve.
Second.
Okay, moving on to findings.
The actual renovations is due to destruction by a fallen tree. Owner did meet with the Historical Commission and has a certificate of appropriateness.
Setbacks improved.
Setbacks have improved. The rear setback has gone from 3.8 to 5. They've increased the utilization of the building by enlarging it, but they are restricted due to septic location, that they can't move the building forward more.
The height is adequate.
Yeah, and height is 21, 6 and a
Just
half.
in the record. But for,
All right, anything else for findings?
No.
Conditions?
Per plans, has to conform with the Historical Commission Certificate of Appropriateness for 18 Locust Street, application number 19-46. 240-3C, 240-216, not substantially more detrimental. And will be used for storage only. Oh, and also the, comply with engineering comments and Concom regarding keeping any stormwater on property.
Okay. Does it for findings and conditions. Motion to approve was made by Ed, I think, and second by Jerry. All
By
those
me.
Oh, I'm sorry, Bob.
Second by Joe.
Second by Jerry. All those in favor?
Aye.
Good evening, thank you.
Enjoy your garage.
Thank you, I will. Oh, yes, thank you.
Yeah, I steal one.
All right, moving right along, we have have application 60-19, Marchicelli, 27 Pequosit Ave in North Falmouth. Let's see if I got them both right.
So being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Mass General Laws, you are hereby notified that Christopher J. Marshelli of Mansfield, Mass. has applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-3C and 240-69E of the Code of Falmouth to construct a second-floor addition in addition to the first floor, which exceeds 20% lot coverage by structures on subject property known as 27 Pequosit Ave, North Falmouth, Mass. For referrals. Engineering has attached multiple comments, including that the applicant needs to obtain a driveway permit. Plans do not show enough information to approve a driveway permit. An apron meeting the driveway requirements must connect the parking spaces to Pequosit Ave road surface. We recommend that this information be added to the plans. Request that the board either require the applicant to obtain an approved driveway permit from the engineering division prior to closing the hearing for the special permit, or that the board include that in their conditions. Note that the existing driveway includes a cobblestone apron that does not contain gravel within the driveway and allows to spill into Pequosit Ave. We will be looking for a different configuration for the proposed driveway that addresses this issue. It isn't clear if the existing post and rail fence falls within the site or within the right-of-way. We recommend that the fence be shown on the plans and indicate if any portion will remain. If any portion of the fence to remain is located within the right-of-way, a license should be obtained from the selectmen, or the fence should be moved out of the right-of-way and onto the property. We recommend that the board add a condition that requires the addition of dry wells, rain garden, or other stormwater measures for roof runoff. Where this site slopes down to the street, we request that erosion and sediment controls are included for the project to protect the town's downstream stormwater system. We recommend that the plans be revised to include a demarcated limit of work and include proposed erosion and sediment control and detail to protect the Pequosit right-of-way, town stormwater system, and abutting properties. We recommend the following condition for any approval: that upon completion of construction, the applicant can post the address for this residence per section 99-1, affixing illegible numbers required, and time limit for compliance. Concom, no comment. Assessors, no comment. Water Department, applicant must apply for upgrade from 3/4-inch service to 1-inch service. Planning, no comment. Fire Department, no comment. Good to go.
Okay. And for the applicant tonight?
Good evening. Mr. Chairman, members of the board, my name's Chris Marcaselli, the owner of 27 Pequosit Avenue. Give you a little bit of history. I purchased this 1948 two-bedroom bungalow back in 2002. Put a lot of sweat equity into it, remodeled it. Raised my family there during the summers. My mom and dad here, we're in the community here. So over the last year, my life has changed, and I'm going to be making this my primary residence. And it's currently a two-bedroom home. I have an 18-year-old daughter in high school and a 20-year-old son. And so I want to provide a home for when they're with me that I have adequate space. And what I'm proposing is an addition keeping the existing home, and proposing two bedrooms upstairs and redoing my bedroom on the first floor. I addressed a lot of the comments that Member Dugan mentioned I did speak with Scott with the engineering department. I did add the paved hard surface, the 5-foot that they required. I put that on the plan, and I left the remainder of the parking, crushed stone, which I have presently and which I prefer. I did add the dry wells, and I certainly can make a revision on the sediment control that they're requiring as far as the engineering department. I also placed, on the plan itself, I took the comments from the water department and showed a proposed upgraded 1-inch service, replacing the 3/4-inch service. My engineer also would provide a proposed septic system. Of course, you know, if I am approved with a special permit, I'll have to get a Title V plan submitted to the Board of Health and get that approved prior to a building permit. So what I'm doing here is essentially this is where I'm going to make Falmouth my permanent residence. I have 2 sisters who live in the neighborhood as well, and that's what I'm looking to do. So I'll be more than happy to take any questions, try to answer them best I can.
All right, start off on this side. Jerry, you got any questions?
No, I guess he had said that he'll get permit for 3 bedrooms from the Board of Health.
Actually, 4 bedrooms. I have 2 existing bedrooms, and I'm adding 2 bedrooms upstairs for the kids.
So you're asking for 4 bedrooms?
Yes, I'm trying to leave the existing structure alone. Yep.
Thank you.
All right. Ken?
What's the overall height of the structure?
It's 28 feet.
The new structure?
The new structure.
Okay. And usually when people are going above 20% lot coverage, we ask for some kind of analysis of homes in the area. I can't really tell from this, the size of your lot, but it looks like it's a pretty small lot.
Yeah, it's an odd-shaped lot as well. It's one of the
Oh, there it is. I'm
hurdles I've
sorry,
had.
9,585 square
Yeah,
feet.
Ken, I'm
just
gonna
under
hand-
10,000 feet, and I
I'm gonna
did,
hand you this just because it's not labeled, but I
Okay,
think
so
it's
it is in there.
So we have what Ken's
It's just
asking
not
about,
labeled.
the bulk calculations.
Right.
But you are on a corner lot.
it's on a corner lot, but it's an unconstructed way, so I did go to the building commissioner, Rod Palmer, and he designated Pequasit as my frontage.
Did he give you a letter by chance? Let me take it.
He signed off on the plan for us, and so as far as, I'm non-conforming on the front, it's a pre-existing non-conforming home. I do meet all the setbacks for the side yard and the rear setback.
On the septic, just because we didn't get a referral in from health, did you run it by the health department, the plans?
I did not, I didn't, because I don't have the plan completed yet, so I have a proposed plan, and I'm confident that the site, I mean, I provided reserve areas for it, so I'm confident that the lot perks. I know the materials there when I did some work when I first bought the house.
Ed, any questions?
No, the only question I had was the height. You answered that.
Mary, anything?
Yeah, I just had one, which was, what is the proposed structure paving parking figure? Because it didn't look like that was correct, but I could be incorrect.
So I went to the building commissioner for a determination on that as well, and if I can get back to there, I did pull up the dimensional regulations, and he gave me this ruling that in the maximum lot coverage, you know, I'm under the 40%, where I'm showing 23.35 for the existing. Go up there. But underneath on his notes, it's excluded from lot coverage of materials considered pervious by the building commissioner, including but not limited to pervious concrete, pavers, and similar materials. So so that's why it did increase from 23.35 to 23.85 when I added the 5-foot apron that Scott from the engineering department requires as a town engineering department requirement.
So on the plan that you have, just for your labels, just for the record.
Yep.
You have the existing structure is 10.35%.
Yes,
The proposed structure is 23.35%.
yes.
The structure, parking, and paving proposed is 23.85, so it's just going up a point percentage?
Yes, and that's because of the 5-foot apron, which is shown on the plan. I'm just rotating the view here. It should load.
Had it there before.
No, under a time constraint.
It's 5 by 22.
It's up there.
Just seems like That's a really small percentage
Yeah.
of grade.
But it's only,
Displaying.
it's
Yeah, the other one on display,
only
yeah.
5 by 22. So that's,
Most of it's personal.
Yeah,
Basically,
so
yeah.
This is all
that was,
question-
It's just a small percentage.
it's just a
of
small
pavement.
percentage because that
Yeah.
5-foot by 20-foot apron
Yeah.
increased the lot
Yeah,
coverage by
got it on
0.5%.
Okay.
shows it on the
I don't know
drawing.
why it's not showing up now. It was here earlier.
Oh, it was here, it's on the drawing.
Yeah, we have the hard copies of the,
Okay. So that was a question that I got from the ZBA, and I went to the commissioner, and that's how that's what he ruled on. That's how he sees it.
Thank you.
any other questions for the applicant?
Is there a full basement?
There is a full basement, yes.
Any finished space or just storage?
No, I'm just gonna use it as storage. Growing out of my shed that I have on the property now.
All right, any members of the public have any questions, comments, concerns regarding this project? Seeing none, back to the board. Think we have everything?
I think so.
All right.
Yes, motion to close.
Second it.
Motion to close made by Bob, second by Ed. All those in favor?
Aye.
And how would you like to proceed? Not everyone at once.
It's giving someone a chance.
Oh, good, you do good.
You've got all the information in front of you.
Not anymore. All right, a motion to approve.
All right, motion to approve by Bob,
Second it.
and second by Ed. Findings?
He's expanding the house for year-round permanent usage, going from a 2-bedroom to a 4-bedroom. The proposed structure will be 28 feet high. Meets 240-3C, 240-69E. The building commissioner has designated Pequasit as a front yard designation. Will need health department approval. There is no health department referral in the application file. So this will also have to be conditioned on approval for the health department for a 4-bedroom system on that site. Structure will be increasing to 23.35%, total lot coverage 23.85. Full basement on property, but just for storage. We'll have to comply with all the engineering comments, and those comments would need to be put into the conditions. We'll need to get a driveway permit and also do house number designation.
Can I suggest that when you mention the increase in lot coverage, you say, but is still in keeping with
But it's in keeping with the neighborhood.
the neighborhood?
Yeah.
There's several houses there that have 2,000 square foot footprints, and
Percentages were submitted to the file for neighborhood calculations.
All right, anything else?
The question, what, the building commissioners are gonna designate the frontage, but he already has an address.
So the frontage will just be for the application.
Yeah, okay, right. Not a new address.
No. All right, so that motion to approve was made by
Well, no,
Bob.
we have to do the
Oh, I'm sorry,
conditions.
conditions, I'm ahead of myself.
So per plans, we'll need approval by the health department for the proposed 4-bedroom septic system. We'll need to abide by all the comments from engineering regarding driveway, runoff, et cetera, and the issues with the right-of-way. And also designate all things asked by the engineering on the plan submitted for the building department.
Okay,
The water
Oh, and the
department
wa-
say anything
yeah.
about increasing the size?
Yeah, and the water service will need to be increased to, I think it was it 1 inch?
1 inch probably.
1 inch from 3/4. Yeah, and then post the address as stated in the engineering comments.
all right, so if that does it for conditions, that motion to approve was made by Bob and second by Ed. All those in favor?
Aye.
Aye.
Thank you all very much. Have a good night.
You too?
Now, let's keep it rolling.
Already, we already gave him?
Oh. make a quick adjustment over here.
All right, so next we have application 61-19, O'Brien trustee, 7 Priscilla Street in T-Ticket.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Mass General Laws, you are hereby notified that Thomas C. O'Brien, trustee of T-Ticket Mass, has applied to the Zoning Board of Appeals for modification of Special Permit 104-18 pursuant to Sections 240-68A, 240-69A, and 240-3C of the Code of Falmouth to convert existing deck into habitable space on subject property known as 7 Priscilla Street, T-Ticket Mass. For referrals, Concom, applicant filed an administrative review with Concom, approved on January 4th of 19. Erosion control and stormwater management should be considered. Engineering general comments, reviewed for public ways, recommended condition that requires the addition of dry wells, rain garden, or stormwater measures. Water Department, no comment. Assessors Department includes lots 4 and 5. Fire Department, no comment. Planning Board, no comment. Health Department, no issues. There is also a submittal of lot coverage in the file.
Okay, and for the applicant tonight?
I'm Greg Jones, architect for the O'Briens. Mr. O'Brien's here as well as the contractor, Chuck, just in case there's any questions of them. We were here before you, I want to say 6 or 7 months ago, requesting that the deck on the rear of the property be converted to a screen porch, an enclosed screen porch. We were here because we were expanding existing non-conforming. We were slightly above lot coverage, I believe. So the project got started. During the construction, the homeowners thought the project would be much better served if it was a year-round space rather than screen porch. So making it a year-round space transforms it into more habitable space, which is the reason we've come back to ask you once again to take a look at the project and consider granting us the special permit to change it from what was a deck to a screen porch now to a year-round space. I'll note that from the beginning, the deck that existed on the property was some 12 by 16 feet, I believe, and that our screen porch was going to be that same exact size. This, changing it from a screen porch to habitable space, we're not changing the size at all, so our lot coverage stays the same as the last time we were here. We're simply asking that it be insulated, heated, and rather than just screens, that it also has windows in it. So the process of changing it from, 3-season room to 4-season room makes it necessary to come and seek this special permit. So I'm happy to answer any questions about that, and as I say, Mr. O'Brien's here as well.
All right, thank you. Mary, any questions?
I don't.
So the only change then is just asking us, for us to add it to habitable space versus a screen porch?
Correct.
That's it. No questions.
Deb?
I don't have any questions. When I drove up, I said, gee, I think I've been here before.
Yes, looks a little familiar.
Deja vu.
Yeah.
Ken?
Got nothing.
All right,
No
Jerry?
questions.
All right, no questions for me, because I remember the project pretty well. Any members of the public have any questions, comments, concerns regarding this project? I'm sure the homeowner's in favor of it. All right, back to the board.
Motion to close.
Second.
Okay, motion to close by Bob, second by Ed. All those in favor?
Aye. Motion to approve.
Second.
Motion to approve by Bob, and it's second by Ed. Findings?
So, motion to approve the modification. The only change from previous permit is that the 12 by 16 screen porch, which was permitted, will be turned into habitable space for year-round use.
Okay.
All other items to remain the same.
Any other findings?
No, because it's just a modification, so we'll just go off the main permit.
Yep. All right.
And the only nonconformity is the setback, well, I guess now they're over 20%.
Yeah, but we already approved it anyways.
Right,
it's the
no, I
same
understand,
size.
I just was trying to
And I guess for
figure
conditions.
out why they were here at all.
Yeah. So conditions just per plans of the, converting it to habitable space, same size, and no other changes from the previous permit.
All right, so if that does it for findings and conditions, the motion to approve was made by Bob and second by Ed. All those in favor? Aye.
Thank you very much.
It's good when you come late in the night.
You guys are getting a little tired, are you? Thanks, guys. Yep.
I think the motion to extend the night was until 10 o'clock. Would anyone like to make a motion to extend it a little further to
10:15.
accommodate?
Before we do it,
Thank you very much.
Thank you.
Oh, you're here for the next applicant.
Oh, you are, then, that's what I was gonna say, I didn't think
I
they
don't know
were
if,
here.
I don't know if the second one will be as quick as your
Thank you
first
so much.
presentation, but just want to anticipate some time.
That's what confused me, I didn't think the applicant was here for Bay Road.
Yeah, so would anyone like to make a motion to extend the time
I
tonight?
moved to 10:15.
Second.
Motion to extend to 10:15 made by Ken, second by Jerry. All those in favor?
Aye.
How the hell they get
They did say just shut it now.
I couldn't figure out how to get that back home.
They're tough sometimes.
Just one more minute.
So up next, we have application 62-19, Samorian, 23 Fay Road in Woods Hole.
Okay, so being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Mass General Laws, you are hereby notified that Michelle A. Samorian of Dover, Mass. has applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C and 240-68B1 of the Code of Falmouth to construct a dormer to the second floor and convert a portion of existing garage space into habitable space on subject property known as 23 Fay Road, Woods Hole, Mass. For referrals, Concom, erosion control and limit of work should be established. Property is outside of jurisdiction. Engineering, general comments about stormwater runoff. They recommend the board add addition of dry wells, rain garden, and stormwater measures. The plans show an existing tree line, but not a proposed tree line. We recommend that a limit of work, including proposed tree line, be added to the plans. The limit of work should include how it will be demarcated in the field and include any erosion and sediment controls required to protect the abutting property. During the site visit, we noticed that locating the property was not easy due to address not being posted out at Fay Road, and the existing number 21 sign was tucked into the shade tree and bushes. We may recommend the following condition be included in any approval. The applicant shall post the address of both residences sharing the driveway per section 909-1, affixing illegible numbers required. Time limit for compliance, both numbers 21 and 23 shall be posted clearly at the end of the driveway as well as on each resident visible from the driveway. Assessors Department, no comment. Water Department, not applicable. Planning Board, no comment. Fire Department, no comment. Health Department, the proposed septic system and house plans match proposing 3 bedrooms. The septic system design appears adequate, with the exception of the water service not being shown. And that is it.
Okay, and for the applicant again?
Thank you. Greg Jones, architect for the applicant, Michelle and John Samorian. We're here, this is actually a guest house to the main property, which is, I believe, 23 or 25 Fay Road, which is just up the dirt drive, so it's owned by the same people. They'd like to renovate what used to be the caretaker's cottage house, with the idea being the owners of the property are getting older, and they envision moving out of the main house into this property, because we'd have it all on one level, and letting their children use the main house during the summer. So in order to accomplish that, what we're looking to do is add some length, a small bit of length to the existing building, this hatched area here, 3.5 feet by the width of the building. A small bay window, which will be in the new living room, as well as on the second floor, you'll see in a moment, a dormer across the back. There's currently a bedroom up here that just has a skylight for a window, so we'd like to put a dormer back there to give them, excuse me, real windows. We intend to keep the property looking very similar to what it does now. It's a lovely place. A couple challenges. There really is no known septic system. We believe this cesspool is on the neighbor's property to the north. The septic line leads out that way to what we don't know. So part of this proposal is to build a new fully compliant Title V septic system. It's noted that there was no location of a water line. Same situation. We can't find where the water line is. Our hope is during some of the demo and renovation, we'll see where the water line exit the house, and we'll more than likely have to put in a new water service because it's probably going to the same place where the septic system goes. So the reason we're here is because this portion of the property, I believe, is 6.9 feet from the neighbor's side lot line, whereas zoning requires us to be 10 feet. So that's why we're expanding existing non-conforming, and the non-conformity is that setback in this corner. Again, I'm happy to answer any questions. It's relatively straightforward, I think. This is the proposed floor plan when we're done. There's a three-car garage bay across here and another garage bay here. So as it stands now, it's a four-car house with 2 bedrooms, kitchen, and a couple bathrooms. It's no longer needed to serve that purpose, so we're proposing to just make it a 1-car garage back here. The owner's master bedroom here on the lower level, master bath, and then open up this space into a more open living, kitchen, dining area. Second floor is fairly straightforward. They probably won't use the second floor all that much. There's a bedroom that exists here now, and our intent is to put a dormer across the back. There's currently a living, sort of sitting room, bedroom sort of place here, and we intend to keep that use. And that's the project in a nutshell. We certainly will oblige all the conditions, including the street numbering, the tree demarcation, erosion control. That's not an issue. So I'm happy to answer any questions anybody might have. That's just a view of the front of the property.
Start off on this side. Jerry, any questions?
Is proposed septic tank going to serve both structures?
No, the main house has its own Title V compliant septic system.
Okay.
So the new one is just for this cottage.
So there needs to be a new water line for the proposed construction?
More than likely, because like I say, we just don't know where the water line is, and likely it's previous one.
You didn't say anything about upgrading from 3/4 to 1 inch?
We may have to, because we don't know what's there now.
Is it on town water now?
It is on town water,
Is it?
yeah.
Okay, I think it'll probably work its way out through the permitting process.
Yes.
Or we may make a condition to check in.
Because right now, the only space there's a very low crawl space that's actually physically impossible to get into. So when we pull up the floorboards during the renovation, we'll get a better sense of where the water line is. That was the same story with the septic system, but we know we have to do a new one of those, so.
Anything else, Jerry?
No, that's it.
Ken?
No, it looks beautiful. Where the 2 of the garage bay doors are now, you're gonna have that nice window.
Yeah, and that mimics the main house, which has some of these curves on it.
Lovely.
No, I don't have any questions.
Bob?
No question.
Mary?
No question.
How old's the property in question? Or
Well,
the building, I should ask.
the main house was moved, my understanding is from Connecticut, as a 1740s colonial that was moved to the property just prior to the current owners. Current owners have owned it since, I think, the 80s. This carriage house, to the best of my knowledge, it just says circa 1900, I believe, in the town assessors. You know, it's probably turned of the century, maybe a little earlier. But it's not nearly as old as the main house.
All right. Any other questions from the board? Any questions, comments, concerns from any members of the public? All right, seeing none, back to the board.
Motion to close?
Second?
Motion closed by Jerry, second by Ken. All those in favor?
Aye.
Aye.
And how would we like to proceed?
Motion to approve.
Second.
Okay, motion approved by Bob and second by Ed. Findings?
Meets 240-3C, 240-68B1. Renovating the existing cottage residence, adding 3.5 feet, they're adding a bay, second floor dormer. Will remain a 3-bedroom. We'll be installing a new Title V 3-bedroom septic for just this cottage. There'll be no increase in height. The existing non-conformity of the side yard setback at 6.9 will remain the same, no increase. We'll need to put a limit of work demarcation on the plan and erosion controls. They're not sure if they need to expand the water service. There was no comment from water in the file. There are comments from engineering that will need to be complied with, again, towards erosion control and for keeping stormwater measures on the property. Oh, and also need to add the addresses, the 2 individual addresses, not only on each property, but also at the driveway. Also meets 240-16, not substantially more detrimental and increases utilization of the property.
All right, conditions?
Per plans.
Probably conditions that are
In the conditions in the file,
in
so
the engineering
to meet all the
department.
conditions mentioned in the engineering, also
There's quite
mentioned
a
in the
few.
Concom,
Approve Title V.
approved Title V by the Board of Health.
Should check with DPW for water line.
Yeah, I mean, they didn't have a referral, but they should check with the building process. Per plans.
All right, so if that does it for findings and conditions, the motion approved was made by Bob and second by Ed. All those in favor?
Aye.
And aye.
Thank you, thanks for sticking it out tonight, I appreciate it.
No, thank you for sticking it out.
Sorry you had to be on the end, huh?
I get paid, so it's,
Understand. Clock was ticking since 6.
All right, so turning finally to our open meeting items, the minutes from October 3rd are tabled. Any board updates?
The recodification date has been changed again to November, I think, 20th or 21st.
Okay, so that
This year
takes
or
care
next
of
year?
recodification.
This year.
Well, this year, but I don't expect it till next year.
Board workshop is this Saturday here in Town Hall at 9 o'clock. Bring your breakfast items, and we'll talk about a few things then. Any future agenda items? Seeing none. There is a 3rd anniversary that was brought to my attention. Ashley.
Oh, yes.
Happy anniversary with your husband.
Happy anniversary.
Sorry to keep you out so late.
If FCTV is on, they can zoom in on Ashley, and she can wave to her husband and also wish him a happy anniversary.
Sorry for embarrassing you. All right, and so we have our workshop Saturday at 9 a.m., and our next regularly scheduled hearing is November 7th, 6:30 here at Town Hall. Meeting adjourned.
What do we need?